Good morning, everybody. It's Monday. Welcome to the Courtroom Files Live. It's great to have you all here. I hope you had a great weekend. We had a busy weekend here. If you'll notice on your screen, we've done some visual upgrades and some content upgrades. I call this Chiron 2.0. We have some motion, some animation now. The crawl at the bottom is a news feed, which is pulling real time from multiple different sources. And my hope is by tomorrow, that feed will actually be available to you in Discord as well. So if you see articles that are of interest, there'll be links there that you'll be able to click on. We're a morning show. People like info in the morning, so it felt appropriate to kind of bring you up to speed on the news while we're also watching court. So let's start our day with Wade Mercer in Florida.
Earlier this year that I think may have been dismissed. Let me look at that and make sure that I'm not getting my cases confused, but I think yours is the case, Mr. Keller. There was an arrest this year for aggravated assault in Hillsborough County, but that case was dismissed according to your criminal history. So I'm going to see if Mr. Tarpey has any additional information that he wants me to be aware of, Mr. Keller, and then I'll listen to the state, and then I'll address your bond status. Anything on behalf of the defendant, sir?
Yes, Your Honor. Firstly, Mr. Keller is a nursing professional. Right now is a very busy time in the season, and he's essential enough staff that it would ask the court to take serious consideration of sort of his role in the public, and in addition to that, sort of the the tone that it sets in the work that he does, that he is somebody that is generally helpful to the community and that wants to help people. In addition to that, he's got excellent family ties. He's been in the community for a long time. He's really not a risk, not for flight, not for the community. And frankly, I think it's in the public interest that he be allowed a bond or really.
Yeah, I think he's entitled to a bond. I don't know what community we're talking about, so let me try to verify that. Mr. Keller, what I've got as an address is not Jackson County at all. It's Panama City, Florida. Is that accurate? Is that your address, sir?
Yes, sir.
Okay, so you may have community ties, but it's not in our community. It doesn't appear, but let me see if the state has anything, and we'll set you a bond. Mr. Mitchell, anything?
We just request a reasonable bond under the circumstances, and that'd be I was going to say subject to random UAs, but I couldn't find any allegations of drug use in there, but we would request that he not possess or consume any alcohol while he's out on bond.
Okay. So Mr. Keller, what I'm going to do is I'm going to set your bond at $5,000 cash or surety. That's a standard bond in this county for that charge. I had a school teacher accused within the last 2 weeks with the same charge, and that was the bond she was set. So that's kind of a standard bond for that charge with someone with little or no prior criminal history. The allegations are that someone has serious bodily injuries, so it's a serious charge. You're gonna have a standard condition, not to possess or consume alcohol. That's a standard condition of every DUI case. You've got the right to post a bond. You can go through a bondsman if you wish. You post a bond, you'll be released. The other thing we're going to do is give you a notice for your court date, for your arraignment date or tentative arraignment date, and that would be December the 2nd at 8:30. Now, if your attorney files a notice of appearance for you, that very well may change the court date, but this is the arraignment date we're asked by the circuit judge to give out for today's purposes. So make sure you stay in contact with your attorney because that court date very well may change, or your attorney may file a waiver of appearance for you. But unless one of those things happens, that'll be your court date. Let me see if Mr. Tarpey, anything else on behalf of Mr. Keller?
Nothing further, Your Honor.
Thank you. Anything, Mr. Mitchell?
Nothing.
Mr. Keller, don't talk about your charge, but if you have a question, and if it's a question I can answer, I'll try to. Do you have any questions?
No, sir. I appreciate it. I just wanted to point out that charge that you brought up, that was actually 2005.
You know what?
The one that was dismissed in Hillsborough County.
And I very well may have screwed that up. You're right. It is 2005, not 2025. I apologize. It was dismissed 20 years ago. That's a non-factor. Since it was dismissed, I didn't take it into account either way. As far as I'm concerned, you have no prior criminal history, but the charge is what's getting you the bond. You're accused of a third-degree felony, and it appears allegedly someone has spent at least 3 or 4 months in the hospital as a result of your allegedly driving while intoxicated. That's what you're accused of. I wish you the best, sir.
Thank you.
Thank you. Thank you, counsel.
Thank you, Your Honor. Thank you, State.
All right. Have a good day, sir. We'll go back to the top of our list then. And that first case is David Bell. Mr. Bell, come on up, please. Mr. Bell, good morning. Mr. Bell, you're here because you've been accused of one count of aggravated assault with a firearm. Mr. Bell, there is probable cause for this charge. I've looked at the complaint. I've also read your criminal history. There appears to be a reoccurring issue over the years with criminal charges that are sometimes allegedly related to mental health issues. Let me see if the attorneys have any additional information. I think you're entitled to a bond, but let me make sure they don't have anything else before I address that. Mr. Mitchell, anything from the state?
We just request that as a condition of his bond, he not possess any firearms.
Mr.
Yes,
McNally,
sir.
anything?
No, nothing, Your Honor.
Thank you. Mr. Bell, I'm going to set your bond at $15,000 based upon the allegations against you as well as the criminal history. It's cash or surety. That means you can go through a bondsman. You don't have to come up with all the money. You do have a condition to have no contact with the alleged victim, and you have a condition not to possess any firearms while the case is pending. Mr. Bell, what that means, sir, is you're going to get to use the phone in just a few minutes, sir. If you post a bond, you'll be released. If you're not able to post a bond, then the public defender's office will be in contact with you in the near future. We're also going to give you a court date. Judge Garcia's next arraignment date, which will be December 2nd at 8:30 will be your court date. The jail will give you that notice in writing, Mr. Bell. You will not get a notice in the mail. They'll put that notice in your hand. So if you do post bond, that's your court date to be back at. If you don't post bond, that still will be your court date. You have any questions, Mr. Bell?
Yes, Your Honor. I do live on limited funds. And I was wondering if I could please ask for a bond reduction, Your Honor.
You can certainly request that at a later court date, but given the allegations are that you fired a firearm at two strangers essentially, and there's evidence to support that, coupled with your past criminal and mental health history, that's the bond I'm setting today. It may or may not get lowered in the future, but for today's purposes, that's your bond.
Yes,
But you have the right to
can you
try to
tell-
post it. You also have the right to ask for a bond reduction at a later date, okay?
Okay. Do you know what the actual amount would be on the percentage? on
If
that?
you go through a bondsman and if the bondsman charges you 10%, that's a lot of ifs, but if that happens, your bond will be $1,500 is what they would charge you.
Okay, all right, I understand this one. All right.
Have a good
Thank
day,
you, Honor.
sir.
Be blessed.
Did you give him
Yes,
the
sir.
December 2nd court date?
Once again, everybody, good morning. Happy Monday. Welcome to the Courtroom Files Live. I actually need to step out of the studio, excuse me, for a minute because I got to help my wife with something. But I'm going to switch us over to Miami-Dade. We'll spend a little time with Mindy Glazer while I go help my wife out. There's always good times on Monday in Miami-Dade, so let's see what's going on there.
પોલીસના વિભાગમાં એમાં હસ્તાક્ષર કરી દો.
You understand so far what's going on?
સમજ પડી બધી?
ખબર પડી પણ મારે કંઈક એ લોકોને મેસેજ કઈ ના મોકલ્યું કે અહીંયા મને મળે લોકો આજે પૈસા મને આપે છે તો રિક્વેસ્ટ કઈ ના થઈ શકે કે અહીંયા લોકો મને છોડે આજે.
So how do I convey to them, my family, that, you know, this is what's going on, and then so that I can be released over here if the bond is posted?
You can use the phone in the jail and call your family.
તો તમે તમારા સગાવાલાને ભાઈને કે કોઈને પણ ત્યાં ફોનથી વાત કરી શકો છો પોલીસ જેલમાં.
Have a nice day.
Thank you.
Thank you, Madam Interpreter.
ઓકે આવજો. જય શ્રી કૃષ્ણ.
Somebody else?
Thank you, Honor. Have a good day, Honor.
Interpreter, please don't leave.
Madam Interpreter, can you please wait? I'm almost done with this calendar. I have something else on the other calendar that's next. Can you wait,
Okay,
please?
Sure, Your Honor. I was actually
Thank you.
having this for one case. Do you know how many? Because I have to actually go to court. for
Just
the-
one other case and I'll do it in a minute.
Thank
Lewis
you.
Corrections, which one?
It's HO, it's in the out-of-state fugitive, in-state fugitive, he's number 9.
And Your
Yes.
Honor, I don't have the case information, so if that can be given.
I'll give it to you. I'll give it to you when we're on it. Okay, just give me a minute. Next, on in-state, out-of-state warrants, Jermaine McLean.
Yes.
Where's Mr.
Metro West number 2, Your Honor.
I'm Mr. McLean, Metro West 2. Sir, good morning. You have an arrest warrant from Oregon. The warrant was issued on November 16th of 2025, which was yesterday. The charge is identity theft. There is no bond on the arrest warrant. I need you to tell me if you want to waive or contest extradition. Waiver of extradition is the quickest way out of this jail. Oregon would have up to 30 days to pick you up. If they don't pick you up within 30 days, I guess after, did his sentence expire or no? Corrections is even open case?
The sentence already expired.
So they have 30 days to pick you up. If they don't pick you up within 30 days, you get released. The other option is to contest extradition and fight the warrant. Then you would be held in our jail up to 90 days so that the state can obtain a governor's warrant to send you to Oregon. Those are the two choices. What would you like to do? Waive or contest extradition?
I do not want to go to Oregon.
You want to fight the warrant? You know you're going to be here at least 90 days and you're probably going to go anyway.
No, waive.
You want to waive and get out quicker? They have up to 30 days to pick you up. If they don't pick you up within 30 days, you get released.
Yes.
You want to waive?
Yes, 'cause I already had a situation with them, like the same thing, and they already told me before when I was in North Carolina that they wasn't going to pick me up.
They may not. I don't know. If they don't pick you up, you'll know soon enough because they'll let you out. But if for any reason you get released and they don't pick you up, you have to go there on your own to deal with the warrant because you're going to keep getting arrested on it. Okay? You
Yes,
understand?
ma'am.
All right,
So I
so
just-
it's no bond, reset date, December 2nd. We'll set it in 15 days to try and get you out of here quicker. Please make sure you sign the waiver paperwork at the jail. It just means you agree to be transported to Oregon.
All right, just it's just one charge, identity theft. That's all.
Yeah, just the one charge.
Oh wow. All right, thank you.
Thank you. Good day, sir. Okay, nobody else is coming back, so thank you, Ms. Ramos.
Thank you.
Okay, let me call up first. Is it Carlos Maya Nunez? Is he the one who needs the interpreter, or is it Alam?
The last name is A-L-A-M.
Yeah, I need Mr. Mahakubar Alam. For the Indian interpreter. Ma'am, do you want the name? What do you want? The case number?
Name and case number and language, Your Honor.
The name is Mahabur. Alam is the last name, A-L-A-M.
Yes. And
The warrant is from Hillsborough County, Florida, HILLSBOROUGH. And the case number is FW25 letter I 02676.
Thank you, Your Honor. And the language is Gujarati again or Urdu or
What?
what?
Oh, I don't know. You want to ask him what languages he speaks?
Hello, Mahabur ji, what language do you, आप कौन सी भाषा बोलते हैं?
Bangla.
Okay, no, Your Honor, he speaks Bangla. आप हिंदी बोलते हैं?
No, नहीं बोलते, नहीं.
Okay, Your Honor, I mean, the interpreter asked him in Hindi and he didn't respond, but then he said that he doesn't speak Hindi, he wants Bangla.
Okay, so I need to pass it for, what is the name of the interpreter? How do you spell it?
But not very well.
Okay.
Okay, yeah, go ahead.
What is he, a Bengali interpreter?
Bengali, Your Honor, Bengali.
Okay, I'll request that right now, Your Honor.
Thank you. Thank you
Okay.
so much, Madam Interpreter.
I'm
Thank
sorry,
you, Your Honor. Have a good day.
1 second. Yes, corrections.
stating that he speaks English.
Oh, he speaks English now?
So you wanted to.
Oh, well, that's good. Thank you. Ma'am, you're free to go. Have a good day.
Thank you, Your Honor. Thank you.
All
Have a
right,
good-
since he's here, we'll do his case first. Good morning. Mr. Wilson, are you speaking to him or me?
I was speaking to you, I speak some English, but he felt more comfortable having a Bengali.
Why don't you let me ask him? Good morning, sir. Mr. Alam?
Good morning, ma'am.
Sir, you have an arrest warrant from Hillsborough County, Florida, and the warrant was issued November 13th of 2025. The charge is for delivery of a controlled substance within 1,000 feet of a child care facility or school, possession of a controlled substance, possession of drug paraphernalia, and looks like another warrant for possession with intent to sell a controlled substance within, 1 second, next page, within 1,000 feet of a daycare facility or school. And then there's another charge, keeping public nuisance at a structure for drug activity. So it looks like there's no bond on the warrant. Can you afford to hire a private lawyer?
Okay, I will hire it. Right now, I don't have any lawyer.
Do you have money to pay for a private lawyer?
I'll try.
Do you own your home?
Yes, I have a mortgage.
Okay, so you're not going to qualify for a public defender. You're going to have to hire a private lawyer.
Okay.
So are you okay proceeding now without a lawyer here?
Yes.
So what's going on is there's no bond on the warrant from Hillsborough County. They have up to 15 days to come and pick you up. So given that it's Monday, hopefully they'll come sometime this week or by next week. But they have 15 days to pick you up. And I'm resetting this case for December 2nd to make sure that you've been transported to Hillsborough County.
Okay.
You may want to hire an attorney as well, sir. These are serious charges, okay?
Okay.
Thank you. The reset date is December 2nd. Have a nice day.
Okay.
Thank you. All right, now on page 1 of the in-state warrant, Billy Champion, he's at Metro West 3. Good morning, sir.
Good morning.
Sir, you have an arrest warrant. It is from Broward County. The warrant was issued February 15th of 2024 for possession, robbery with a firearm, burglary to an unoccupied conveyance, and loitering or prowling. I will appoint the public defender's office for you. Unfortunately, there is no bond. You will have to wait up to 15 days for Broward County to pick you up. Your case is reset here December 2nd, and make sure you are transported there. And also you have another warrant as well from Broward, looks like, for criminal, for robbery and attempted robbery and another robbery. And it says no bond on that warrant too. So, and then you got another warrant that's from Palm Beach County it was issued on August 1st of 2024 for robbery with a weapon, no firearm or weapon. So the public defenders, oh, you got one more. Keep turning the page, you keep having more warrants. You have another warrant from Broward County issued May 6th of 2024 for robbery, no weapon, and grand theft with a firearm, or it says grand theft of a firearm. And burglary, that one is no bond. So the public defender's office is appointed for you in all the cases. There's no bond. You're going to have to wait up to 15 days. You'll probably go to Broward County first and then to the other counties. The reset date is December 2nd, and make sure you've been picked up. Okay, have a good day. Thank you.
Can I ask a question?
Yes, sir.
How many, so it's 2 robberies and 1 armed robbery?
That's what it looked like. You got a bunch of cases. Let's see, three in total, 2 from Broward, 1 from Palm Beach. All right,
2
once
from
you get there,
Broward.
you can discuss it with your public defender and they'll explain everything.
2 from Broward, 1 from Palm Beach. Okay.
Have a nice day. Reset December 2nd, no bond. Next, we have Alexander Sokol. He's over at Metro West 4. Good morning, sir.
Good morning, Your Honor.
You still have what's his name, Ms. Seltzer's your lawyer?
No, I have a public defender.
Oh, okay. So you got arrested on a warrant from Broward County. The warrant was issued June 20th of 2025, and the charge is violation of probation. So I will appoint the public defender's office for you. There is no bond on the warrant. You will have to wait up to 15 days for Broward County to come pick you up. They usually come once a week, so you shouldn't have to wait that long. And the case is reset here for December 2nd to make sure you've been transported to Broward. Have a nice day, sir.
Your Honor, I just finished my Miami case. It's been 5.5 months. I have a 7-year-old mother. Is there any way I can get ROR? Because they just...
I can't do that. You have to talk to the judge in Broward. They usually come once a week, so you should be going sometime this week to Broward.
Understood. All right, thank you, Your Honor.
Next case is Kenny McNabb. Mr. McNabb here? Is he at TGK?
I think it's in pre-trial, Your Honor.
I don't see him on Zoom. I'll pass it. He has a couple of cases. Then we have Jonathan Garcia. He's over at Metro West 5. Sir, do you speak English?
Yeah, can I use the interpreter for Spanish? Better.
Okay. Un momento.
Thank
Sir, you have an arrest warrant from Martin County, Florida. The warrant was issued August 21st of 2025.
Ok, señor, usted tiene una orden de arresto del condado Martin en el estado de la Florida que fue emitida el 21 de agosto del 2025.
The charges are failure to appear for driving with a suspended license and failing to appear for arraignment.
La causa es por no comparecer para un caso de manejar con licencia suspendida y no comparecer para su lectura oficial de cargos.
I will appoint the public defender's office for you.
Le voy a nombrar la oficina del abogado de oficio para que lo represente.
There is no bond on the warrant. You're going to have to wait up to 15 days for Martin County to pick you up.
No hay fianza en la orden de arresto. Va a tener que esperar hasta 15 días para que lo vengan a recoger de Martin County.
So
Gotcha.
just reset December 2nd and make sure you are picked up. If you have any questions, please call the public defender's office. Have a good day.
Vamos a aplazar poner su caso en calendario para el 2 de diciembre para asegurarnos que ya lo han venido a recoger. Si tiene alguna pregunta, por favor, llame a la oficina de los abogados de oficio.
Okay.
Okay?
Gotcha.
Okay, thank you.
Correct, Your Honor. No bond.
No bond, no fianza. Reset December 2nd. Wait a second. I gotta clean my desk. Too dirty.
Your Honor, can we go back to Ms. McNabb? She said she's raising her hand.
What?
She's raising her hand at pre-trial for Mr. McNabb.
Oh, okay. Got it. Thank you. Good morning, Mr. McNabb. Are you there?
How you doing, y'all?
McNabb, good morning.
Good morning.
Paperwork here. 1 second.
Yeah, I got the first two. All right.
All right, Mr. McNabb. Sir, you have an arrest warrant. It is from Broward County. The warrant was issued June 5th of 2025. The charge is violation of probation. I will appoint the public defender's office for you. There is no bond on the warrant. You will have to wait up to 15 days for Broward County to pick you up. They usually come once a week. You shouldn't have to wait that long. And the reset date is December 2nd to make sure you are picked up. Okay? Oh, you have another warrant too from Broward that was issued July 30th for failure to register a vehicle. The bond on that is $50, but you're being held with no bond on the other case. So we're resetting both cases for December 2nd to make sure you're picked up. Have a good day.
Thank you.
Thank you, sir. Okay, moving right along. Next is Derek Smith. He's at pretrial. Good morning, Mr. Smith. You have an arrest warrant from Broward County. The warrant was issued September 6th of 2025. Not in custody, capias for aggravated battery on a pregnant victim and operating without a valid license. I will appoint the public defender's office for you. Anything, Mr. Wilson? Did you hear from Broward or no?
No, I haven't heard back yet, Your Honor. We set to the PM and
I'll reset this case in the afternoon to see if Broward County will agree to a bond. All right, so it's reset for 1:30. We'll see you later.
Okay.
What?
I said thank you very much, Your Honor.
You're welcome, sir. Next we have is Willie Hickson. He's at Metro West 6. Good morning, sir. You have a warrant from Broward County. The warrant was issued on September 11th of 2025. The charge is violation of probation. I will appoint the public defender's office for you.
What was the like?
It just says violation of probation.
Just says violation.
I don't know the underlying allegations of the violation. It just says violation of probation. So I'm appointing the public defender's office for you. You can call them later and ask some questions. Maybe they can help you. But right now, there's no bond on the warrant. You will have to wait up to 15 days for Broward County to pick you up. And they usually come once a week, so you shouldn't have to wait that long to go there. The reset date is December 2nd to make sure you're picked up. Okay, you understand?
Yes, ma'am. Would I have to sign anything?
No, you don't sign anything for the in-state warrants.
Okay.
Have a nice day, sir.
You too.
Thank you. Next is Richard Hauser. Good morning, Mr. Hauser. Sir, you have an arrest warrant from Duval County, Florida. The warrant was issued on November 6th of 2025. The charges are driving with a license that's suspended or revoked. Your total bond is $2,503. Sir, can you afford to hire a private lawyer?
No, ma'am, but my wife paid the bond.
Okay, so they made you come to court first. I'm sorry you had to come here. I'll appoint the public defender's office for you. You should pay the bond here in Miami and get out quicker. I don't know if she paid it up in Duval County in Jacksonville.
Here, ma'am, next to the jailhouse.
I'm sorry, Your Honor, for Mr. Hauser. I think Warren just called and added something, the total bond is $5,006.
What happened? Is another warrant?
And it says count two resisting officer without violence to his person. Bond, 2,500 makes it total bond, must have two counts, $5,006.
Okay, looks like you have another warrant also. What was that? So resisting an officer without violence, I don't see it here, but they say you have one, and that bond's also what'd you say it is, $2,503 too? Corrections, what's his total bond? I can't hear you very good.
Sorry, Judge Blake.
It's not you, it's the microphone.
Total bond is $5,006.
$5,006 is your total bond.
Okay, so my wife can drive down here with the $200 and bond me out today?
Contact the bondsman so you can get out of jail. It's better to do it in Miami, okay?
Yes, ma'am. We've already paid $250 down here.
All right. Good luck to you. Reset date December 2nd. Thank you. Make sure he bonds it out, it was transported. Next, Carlos Maya Nunez. We're almost done with this calendar. It's taking me an hour to do this, the warrants. I don't know why they don't give it to the misdemeanor judge to do. Yeah. I got like every time I see a bunch of shifts, I'm like, I'm gonna be busy. Okay, good morning, sir.
Spanish interpreter, you are?
Spanish, please. You were arrested on a warrant from Manatee County, Florida. The warrant was issued October 10th of 2025.
Ok, señor, usted fue arrestado porque tiene una orden de arresto del condado de Manatee, del estado de la Florida, que fue emitida el 10 de octubre del 2025.
The charge is conspiracy for trafficking in phenylethylamines. I don't know what is that? MDMA?
Fentanyl? No.
Yeah, that one. I can't pronounce it. Phenethylamines. It's a trafficking in a controlled substance and 2 counts.
Ok, tiene tiene 2 causas por conspiración para traficar sustancias controladas.
I'll tell you what it is. Also, I will appoint the public defender's office for you.
Le voy a nombrar la oficina de los abogados de oficio para que lo represente.
By the way, it's Molly drugs, not the little fish. I guess the controlled substance people ingest. You know, they got the little black mollies and fish tank. It's not. These are drugs. Anyway, that being said, you got to wait up to 15 days for Manatee County to pick you up since you have no bond on the warrant.
Ok, señor, no hay fianza en la orden de arresto, por lo tanto tiene que esperar hasta 15 días para que lo vengan a recoger del condado Manatee.
The reset date is December 2nd, and make sure you get picked up. If you have any questions, please call the public defender's office.
Okay, la fecha para volver a comparecer acá es el 2 de diciembre, siempre y cuando no lo hayan recogido. Si tiene alguna pregunta, puede comunicarse con la oficina de los abogados de oficio.
Have a nice day.
Que tenga un buen día, señor. Ya se puede retirar.
Next.
It's the Courtroom Files Live. It's a Monday. Welcome. Good to have you all here. Let's rotate back here to Judge Wade Mercer. It seems like they did a warrant sweep for sure in Miami-Dade over the weekend. That was a lot more of that than we normally see. But let's go back to Judge Mercer and finish that up.
Was this one county or state? This one was state.
It's state.
Possession of cannabis with intent to distribute, trafficking in controlled substance, and 2 counts of battery on a Leo. That's law enforcement officer. I've read the complaint. There is probable cause. I've looked at your criminal history, which is one of the longest criminal histories. I may have been the longest one I've seen this year. I think you've been to prison 4 times. Probably may have.
But I've been out a long time.
May have 20 felony convictions on your record, so none of that helps you. But you're entitled to a bond, as far as I can tell, Miss Rafield. Let me see if the attorneys have any additional information, ma'am, before I set that bond. Mr. Mitchell, anything?
I was just looking and trying to calculate what I think her co-defendant got over the weekend, Mindy Rafield. It looks
I
like
got it, but her bond's going to be higher because her criminal history is I don't know what the other person's criminal history was, but her history is not good at all.
But we would also request that she be subject to random UAs.
Thank you. Mr. McDaniel?
Nothing, Your Honor.
Ms. Rafield, the introduction of contraband is going to get you a $10,000 bond. The same charge will be on your 2 batteries on law enforcement officers, $10,000 each. Possession of cannabis with intent to distribute is a 3rd-degree felony, so that'll be a $5,000 bond, and your trafficking bond will be $75,000 based upon your long criminal history. Ms. Raphael, when you add those together, your total bond is
I think 110 is what I got.
$110,000 cash or surety. You have a condition of random urinalysis. I'm going to ask the jail to give you a notice for your court date, which would be December the 2nd at 8:30. Ms. Raphael, you will get to use the phone in a few minutes, ma'am, to post the bond or try to post the bond. You also have a condition of no contact with the Florida Department of Corrections while this case is pending. Ms. Raphael, do you have any questions?
Yes, is at any time can I speak with Mindy Raphael, who
What's
I
your
am
relationship?
legally
What
married
is your
to?
Say that again. That's your spouse? Okay.
Yes, sir.
Okay. Let me answer that as clear as I can. I am not putting any condition of no contact between the two of you because of your relationship. However, I do not know if the first appearance judge that first appeared her put a condition of no contact. So normally I would put a no contact condition of individuals who are not related. But so I don't know what that judge did. So all I can tell you is you're not prohibited from having contact with her. Let me ask the jailer, Sergeant, do you know if Miss Mindy Raphael has a condition of no contact with Laura Raphael?
Not that I'm aware of.
Okay. So unless that judge put a condition of no contact, then there isn't one. I'm certainly not doing that because of your legal relationship. Okay.
Great. Well, I just need to see, we have animals at the house that nobody is taking care of. So I need to talk to her and see who she got in touch with, or.
Did she post the bond that she said, or is she still there?
I think she's still there.
Yeah, I'm sure she'll be bonded out.
Okay. Well, the jail has certain policies also about individuals having contact with one another, but I don't run the jail. That's their call. Wish you the best, ma'am.
Okay, thank you.
Yes, ma'am. Logan Tanner is next. Mr. Tanner, good morning, sir. You're here because you've been accused of one count of driving under the influence, one count of intimidating or threatening a witness, a law enforcement officer, one count of refusal to submit to a breathalyzer, and you've been accused of violation of probation out of, I believe you're on probation out of Bay County. I don't think I wrote that down. So let me deal with that first. On the Bay County violation of probation, you're going to be held 10 days. I'm going to ask Mr. Mitchell to notify
He's going to be pleading, but it's 7 days, but I don't know.
7 days.
We don't need a hold if he's pleading.
Because he's pleading. Okay, so scratch that. I'm going to hold you on that case, but since you're entering a plea in the other case, you're going to be there a lot longer than 7 days. In the other cases, the new cases, I'm going to appoint the public defender's officer to represent you. I'm going to ask that you listen to your attorney, Mr. McDaniel.
Your Honor, I've communicated with Mr. Tanner. He's going to plead of no contest to the charges as listed. The understanding he'll be sentenced to 90 days in the county jail, 1 day jail credit. Refusal to submit be 60 days in the county jail, 1 day jail credit, all run concurrent. That will resolve this case today, be adjudicated guilty. He has signed his plea waiver form, waives his right to jury trial and call witnesses.
You want the standard language that you often ask for about plea not being used against him.
And plea not, and we'd ask the court not to use the plea itself against him, but obviously they can call witnesses and, and convince the judge that he violated his probation if the state and Bay County chooses to try to go down that route.
Thank you. Mr. Mitchell, is that agreeable with the state?
It is, Your Honor.
Mr. Tanner, did you hear that agreement?
Yes, sir.
Do you have any questions about that agreement?
No, sir.
And Mr. Tanner, is that the plea that you would like to enter?
Yes, sir.
Mr. Tanner, I'm going to accept your plea of no contest, sir, to the charge of driving under the influence, intimidating and threatening a law enforcement officer, and refusal to submit to breathalyzer. I'm going to judge you guilty of those three offenses. On the first two, the DUI and the assault on the Leo, I'm going to sentence you to 90 days in jail on each case concurrent, impose a standard court cost and fines to the DUI, which are $1,078, give you 1 day credit. On the refusal, the sentence will be 60 days in jail because that's a second degree misdemeanor. It's also concurrent, which means one sentence, essentially 1 90-day sentence. You're going to finish the 60-day sentence before you finish the other sentence. Obviously, you have 1 day credit on all three cases, all cases concurrent. I'm going to waive the court costs and fines in counts 2 and 3. Mr. Tanner, there's a condition of the plea that says that this plea cannot be used against you to violate your probation. Now, as Mr. McDaniel mentioned, they still can use the incident. If they want to call witnesses in a VOP hearing, that's up to them. The state can do that. But what I'm saying is if they try to use what happened today, the plea itself, I will let you withdraw this plea. Normally that prevents the state attorney's office from trying to just use a piece of paper to violate your probation, a certified copy of the conviction. It makes them call witnesses if they want to use this incident. They very well may. So Mr. Tanner, when you finish the sentence, if they want you in Bay County, if they have a warrant for you, then we're going to honor that. We'll see if they have a warrant. If they don't, and you finish the sentence, you'll be released. And you certainly may or may not be entitled to some gain time under Florida law. I would encourage you to talk to the jail staff about that. Mr. Tanner, do you have any questions?
No, sir.
All right, sir. Wish you the best. We have Tristan Kirkland. Mr. Kirkland, good morning. Mr. Kirkland, you're here for first appearance accused of one count of reckless driving and one count of aggravated fleeing and eluding. I believe that's a second-degree felony you're accused of. I'm going to appoint the public defender's office to represent you, Mr. Kirkland. I don't, Mr. McDaniel, Mr. Mitchell, I don't think I saw any criminal history, but he does have a second-degree felony. So I'm going to ask that you listen to the attorneys. We're going to see if they have any additional information, Mr. Kirkland, before I set your bond. I think you're entitled to one. We'll see what the attorneys have to add. Mr. Mitchell, anything?
Not this time, Your Honor.
Thank you. Mr. McDaniel.
Your Honor, just that he's, local in this area, if I recall, he's 20 years old. Just take those things into consideration.
He's actually 18.
Or,
I think.
or 18 years old. I'm sorry.
18
years old. It appears he's just.
Mr. Kirkland, don't talk about your charges. You started to say something a moment ago. Do not talk about your charges. We are being recorded. You may just be going to correct Mr. McDaniel on the age. Is there anything else that you want me to know for bond purposes, sir?
I'm pretty much homeless at the time.
Okay. Well, the allegations are he was going 100 miles an hour in front of the area in front of Eastside Baptist Church, which is a, depending on the time of day, could be a high volume traffic area. Mr.
Yes,
Kirkland,
sir.
on the second degree felony, I'm going to set your bond at $10,000. On the reckless driving, your bond's going to be $2,500. Mr. Kirkland, your bond is $12,500 cash or surety. I would like to fashion something regarding the driving conditions. I don't know that no driving is appropriate. I don't know that it's not appropriate.
There's a chance that his license could probably be suspended.
I think that happens upon conviction.
Okay.
Not until then. What I would do is no driving until you do a driver improvement course or something like that. I don't know. Mr. Mitchell, what's the state's thoughts about him driving?
I mean,
the speed's just what's concerning me.
I mean, that sounds like a good idea. Like no driving until completion of a driver improvement course as part of a condition.
Mr. McDaniel, any thoughts on that?
Mr. Kirkland, you don't mind taking I think it's a 4-hour class you take online, taking a class before you drive and have that, file that completion of that class with the court file, the clerk of court when you're done with it. If you bond out, that's you told me you were homeless, so I don't know. I mean, if your parents want to come help you out or whatnot, but they may end up helping you out. Is that all right? You do that before you drive?
Yes, sir.
I don't think I have a problem with that.
So, Mr. Kirkland, I am going to have a condition, no driving unless and until you complete a basic 4-hour driver improvement course. I think I'd just feel a little bit better about you driving if I felt like you were kind of refreshed on the danger of it based upon the allegations against you. So when you get out, you post bond, take a basic 4-hour driver improvement course and either have that certificate of completion with you and file it with a clerk. And then you'll be able to drive all you want as long as you've got a valid license. Now, if you're convicted of this charge, there may be license implications. But right now at the accusation stage, I don't think that your license is suspended as far as I know. You'll get to use the phone in a few minutes, Mr. Kirkland, to try to post a bond. I'm also going to ask the jail to give you a notice for your court date. And that would be December 2nd at 8:30 a.m. Mr. Kirkland, do you have any questions?
No, sir.
All right, sir. Wish you the best. Sarge, I think that's everything on my list unless I missed something. Anything else from the jail this morning?
No, sir, that's everyone.
Let me see if the attorneys need you before I know we've got one case in the courtroom. Mr. McDaniel, Mr. Mitchell, do y'all need Sergeant Gross or anything before, or can we let them go?
Nothing at the jail, Your Honor.
Oh, Your Honor.
Thank you, Sarge. We'll see you tomorrow.
Thank you.
Does Judge Garcia have this connection?
Not today.
Gary, no? Okay, so we'll just stay on the same connection then. We have one case in the courtroom, and Mr. McDaniel, I'm pulling that up now, but if you can put the style of the case on the record, that'd be great.
Your Honor, 25487 Charles Smith.
All right, Mr. Smith, I got your case pulled up here. It looks like this case was set for a jury trial this morning. It was set for a plea on Friday. You didn't show up Friday, but I knew that you hadn't signed a notice to be here. It was an agreement between you and Mr.
There was
McDaniel.
a misunderstanding.
Just a second.
Yes.
And so I didn't issue a warrant because I don't think legally I could, because I knew you already had a notice to be here today. So we decided just to see what happened today. So Mr. McDaniel's going to tell me where we stand, and we'll give you a chance to say anything if you wish. Mr. McDaniel.
Your Honor, we're going to enter a plea of no contest, the charge as listed, and we're going to ask the court to sentence him. And I think the state's going to, say whatever they want to say. And I think I know what they're going to say, but we're just going to ask this to take care of. And this right here is waiving the right to a jury trial and call witnesses at that trial. Otherwise, we're just going to have a trial. But right here's where you sign. This will be your date of birth. You want to sign that?
That's what we're here for.
Mr. Smith, you need to understand that you've got the right to a jury trial. You've exercised that right because when you didn't show up Friday, the attorneys agreed it wasn't going to be a trial today. So if you exercise the right to jury trial, we're going to set it for our next jury trial period. If you sign this paper, you're waiving your right to a jury trial. You're also waiving your right to call and cross-examine witnesses. There won't be any trials, there won't be any witnesses. And lastly, you're entering a plea of no contest to a charge of exposure of sexual organs, which is a first-degree misdemeanor. So the maximum penalty is a year in jail. I'm not saying I'm going to sentence you to a year in jail. I don't think the state's asking for that. I'm not sure what they're going to ask for today, but that's the maximum penalty. Do you understand all of that?
Yes, sir.
And knowing all of that, you want to plead no contest to this charge and waive those rights?
Well, me and my lawyer, we couldn't just seem to get on the same page. It was pretty much a repeat of a DUI case I had a couple years ago when we got the conflict of interest. So I just feel like it's best for me to go and take care of this and apologize to the court. I'm approaching 50 years old and I don't have it in me. I just want to get on with my life and work. And
so you've got all the rights I've said, and if you want to go to trial, that's perfectly okay. And we'll cross any bridge, any issue that you raise. But what you've got to decide today is, do you want to plead no contest or not? And that's entirely up to you.
The state's offer the 60 days.
The state's offer of 60 days was for last Friday when you didn't show up, and I haven't heard yet why you didn't show up. So I'm going to listen to that. You need to understand, if you enter this plea, I'm not saying I'm going to sentence you to 60 days. I don't know what I'm going to sentence you to. I want to hear from you or Mr. McDaniel on why you weren't here Friday when we had a jury coming in today. If you want to take the offer or not, that's what you got to decide, that if you want to enter a plea or not. Do you have any questions?
No, sir. I just want to get out of the court's way and get this behind me.
Okay, so does that mean you want to plead no contest, or is
Yes,
that?
sir.
Okay, so what I need you to do is sign that form that I've already explained. That will enter your plea of no contest and waive those rights.
Well, I apologize for wasting any of the court's time.
No, you haven't wasted our time. It's fine. I want to hear what happened Friday and anything else that you or the state thinks is important. That's your date of birth, not today's date. Your date of birth goes on that line. So I'm going to accept the plea of no contest entered by Mr. Smith. I'm going to find it's freely and voluntarily entered with the advice of counsel. Now, as far as sentencing goes, is the plan to go ahead and impose sentence now? You okay with that, Mr. McDaniel, Mr. Mitchell?
Yes,
Okay,
sir.
so Mr. Smith, let me start with you. We had you scheduled to be here Friday at first appearance, and there was a misunderstanding. You've told me that much. What
Yes,
happened with you being here Friday?
I was, like I told him when he called, he said I still had a chance, but I was working, trying to make up some money and get some of my affairs in order so I could take this plea. And like I got a dog and I had to make sure she had a place to stay and my home was going to be all right while I take care of this charge.
Did you call and say, I'm not coming, I'm not going to be able to make it? Did you call your attorney?
I
or
thought
did-
he was telling me to be up here 8:30 Monday. That was the misunderstanding.
Well, you'd already signed a written notice for today. That was
Yes.
a written notice you got weeks ago. So he got a phone call, said we can enter this plea on Friday if you want to take the plea, or what was?
No, he called me and I was too far out. I couldn't make it back when I was working.
Where were you at?
I was over on the other side of Bonifay.
What kind of work was
Working
that?
a little bit. I was working with a buddy of mine's grandfather. He does. Well, he buys, sells, goes to auctions and fixes up tractors. And I was just helping him move some stuff around because he can't do a lot of it on his own. And
All right, let me see if Mr. McDaniel has anything else to add. Mr. McDaniel?
Your Honor, I don't have anything to say. I kind of could have been in miscommunication.
Okay,
Apologize about that also. So,
thank you. Mr. Mitchell, anything from the state?
As it regards to Friday's incident or sentence?
Sentence overall or Friday's incident?
Okay, so The state's offer has been the same as the first appearance offer that was offered when he was initially arrested on this one. It's been 60 days jail. The victim is in agreement. One of the other witnesses that was also the property owner at the time is also in agreement to that. They just wanted to say that they just want him to stay away from their property, stay away from them. And I did want to put on the record that he has been officially trespassed. So if he goes back over to Mr. McCance's property, which is where the victim lives also, that he could be facing trespass issues.
Is there any kind of injunction or anything in effect?
Not that I'm aware of.
So you don't think they've even applied for one as far as you know?
For an injunction? No,
Okay.
I'm not certain.
I talked to them, they really.
Okay. All right. So, Mr. Smith, after hearing from you and hearing from the state and defense, I still think the offer made is reasonable, and there could have been a miscommunication about the dates. So I'm gonna give you the benefit of the doubt, but I am going to impose a sentence that was been offered to you since day one, which was 60 days in the Jackson County Jail. I'll give you credit for any time that you've already served, which is 4 days credit. I'm going to impose a standard court costs and fines for that charge. Is that a regular court costs and fines of $370, Madam Clerk, or is it a different amount? $370 court costs and fines. So, Mr. Smith, what that means is you've got 56 days left at most. Now, let me tell you what I mean by at most is under Florida law, you may be entitled to some gain time. So when you get to the jail, you can go to the jail this morning. They're going to, you need to talk to them about the trustee program if that's something that interests you, because you may, I'm not promising you this is just something I'm telling people, that you may qualify for extra gain time by working at the jail or for following their rules. So you need to talk to them about that. So you've got 56 days left at most. It's possible you'll do less than that, but I can't promise you that. I can tell you that's something you need to talk to the jail about. They determine gain time, not me. There's no probation involved in this sentence, and you've heard what's been said about the trespass, so be aware of that. Do you have any questions?
No, sir.
All right, we're going to give you some paperwork, sir. Adjudicate guilty. We're going to give you some paperwork. We're going to send this paperwork with you, and Sergeant Applewhite will get somebody to transport you to the jail, Mr. Smith, and I wish you the best, sir.
Thank you.
Thank you.
Okay, friends, let's step out of Florida now. We've been there for like 40 minutes. That's long enough. Let's go to Texas. Say good morning to Judge Stevens. Hi, Ellie.
Stay here.
41591, the state of Texas versus, God bless you, Jacarius Avante Francois. That's you.
Yes, sir.
And you were here with Mr. Turk, your attorney and the state's attorney. Thus, the defendant waive a formal reading of the indictment and arraignment. Can we proceed in a summary fashion? In summary, sir, this indictment alleges that on or about December 13th, 2022 in Jefferson County, Texas, you committed the third-degree felony of assault on a pregnant person. Do you understand what you were charged with?
Yes, sir.
A third-degree felony is what this case is all about, which means you face a term of not more than 10 years or less than 2 years in prison. In addition, a fine may be assessed not to exceed $10,000. Do you understand?
Yes, sir.
Agreement has been reached in your case where you would be pleading guilty, placed on deferred or unadjudicated probation, which can be up to 10 years in length. And there would be terms and conditions of probation, which are normal and customary for this type of offense. Is that your understanding of the agreement?
Yes, sir.
If I follow this, you have no right of appeal of your case. Do you understand?
Yes, sir.
How do you plead to this charge, guilty or not guilty?
Guilty.
What do you say?
Yeah.
What- Okay. Are you pleading guilty voluntarily and because you are guilty? I'll show you what's marked as State's Exhibit 1. Did you sign that document voluntarily? Understand it, discuss it with your attorney. Are the contents true and correct?
Yes.
State's Exhibit 1 tendered into evidence without objection admitted matters and intervention presentation. How long was he in jail?
Thanks.
Basically.
Reject.
Thanks.
Judge, Mr. Francois saying he was in jail for 5 months.
Among other things, this states exhibit 1 that you are mentally competent to enter your guilty plea. It's freely and voluntarily made. You know what you've been charged with. The indictment's been read to you. You've read it. You were guilty of the crime charged and any lesser included offenses. You were giving up your rights to a jury trial and the rights to the appearance, confrontation, cross-examination of witnesses. Totally satisfied with the representation provided by your lawyer. All of this is true. It states, so help you God. Yes, sir. States exhibit 1 is part of the record for all purposes. Pre-sentence report is waived here.
Yes, Judge.
Stand by.
Her record show he was in custody for 153 days on this.
That's what she says. Yeah, that's what it's showing. Y'all are working off the same page. That's great.
So, thank you. Test.
All right. Anything further on this?
No.
I'm going to make the finding that and again, you are pleading guilty today voluntarily and because you are guilty. All right. I'm going to make findings based upon state's exhibit 1 here that's been signed. That this states you are mentally competent to enter your guilty plea. It is freely and voluntarily made. You understand and appreciate the consequences of pleading guilty. There's sufficient evidence supporting your guilty plea from state's exhibit 1 admitted here to find you guilty beyond a reasonable doubt. And you are guilty of this crime and any lesser included offenses. I am going to find indeed you are mentally competent to enter this guilty plea. It is freely and voluntarily made, even though there is sufficient evidence supporting your guilty plea to find you guilty beyond a reasonable doubt. I'm going to defer any finding of guilt, follow this agreement, and place you on deferred or unadjudicated probation. This will be for 10 years. You do well, it can be shortened to a third. There will be terms and conditions of probation which are focused on this type of case.
I need to interrupt you on,
Okay.
On these type of matters. This is an area in which the court cannot reduce the amount of time on the probation on domestic violence related.
I know, I'm going to place him on 10 years deferred or unadjudicated probation.
You made the statement that if he did well, you could reduce it by a third.
Okay.
The law says that you cannot.
I'm sorry.
That's.
Judge, we also discussed a 5-year defer.
And that's one of the reasons why I agreed to 5 years and I hate to interrupt the court, but that's the reason why I interrupted the court.
Okay, this Family Violence Act.
Yes, sir. So I'm asking that you approve the 5 years, Judge.
All right, then the court will, and that's agreed upon by the defense. I'm going to follow this recommendation of both parties, and you will be placed on deferred or unadjudicated probation for 5 years. There will be terms and conditions of probation, which are normal and customary for this type of offense. The court is looking at this probable cause affidavit, which is most disturbing. You with me? This is for you.
Yes, sir.
This probable cause affidavit is most disturbing. Okay. This, the victim here was 5 months pregnant with your child. She was taking a shower when you went over to her house, punched her in the stomach. The pregnant lady punched her in the stomach. She was nude. She was unable really to be able to defend herself, put in a bad spot. She says you also picked up a kitchen knife and stated you would kill her. You broke her phone. Police were called. They had visible injuries to her face, scratches on her chin, swollen side of her face. You fled, of course, before the police could arrive. And then, since the incident had occurred, according to the probable cause affidavit, you subsequently called her threatening violent acts. What else could you have done wrong? I can't imagine really a more selfish act could be done than punching a pregnant woman in the stomach. Shame on him. Mr. Man, Mr. Gentleman. And it's your child, right?
Yes, sir.
Punching the mother of your child's stomach, 5 months pregnant. Well, it's about as low as it can get. You've got 153 days. I can sentence you up to 180 days as a condition of probation, and you're going to get all of that. You've still got 27 days to go. You're going to go back to jail. You're going to get every minute of jail that you can. Don't look at him, look at me. I can sentence you as a term of probation to 180 days. You have 153 days credit. You're going to do 27 more. To the last second for this. Yeah.
If I may, Mr. Francois has seen the error of his ways and he is currently enrolled.
How does he take back punching a pregnant woman in the stomach? And he's seen the error of his ways? He has? How long did that take? I mean, I don't mean to be facetious, but this is clear to everybody on this planet that this is wrong. And I couldn't care less the way you think about this. Really? What are you upset about? That you're being held accountable to assaulting a pregnant woman? This upsets you? You find something unfair about this? Speak. Do you? Or do you think this is atonement for what a terrible error you did? Or am I putting words in your mouth? Because I don't hear much regret.
Your Honor, I'm not saying anything I did was right.
Okay. All right. So, yeah, go ahead.
Yes. I have made changes in my life.
How do you take back punching a pregnant woman in the stomach? And what kind of harm can that do to a fetus?
I can't.
Immeasurable. No, you can't. But you can, by your actions, do better. You can also, by the terms and conditions of probation that I'm going to set, be an example for others that this is not acceptable. You're going to talk to him while I'm speaking to you?
Oh, so.
Is this boring you?
No, sir.
What?
Judge, if I might finish.
Go ahead.
He's been on bond for 2 years at this point, had no issues. He is currently enrolled in a welding certification process. He graduates next month. So putting him in prison right now, or in jail, thwarts his entire life. I understand what I'm saying is at that point, you're setting.
You think I'm sorry for him? I feel sorry for the fetus and the pregnant lady who he punched at 5 years, at 5 months pregnant. That's who I'm feeling concerned about. Or am I missing the boat here, gentlemen?
You're not at all, Judge, but I will.
He's going to do 180 days and he still has 27 days. Do you work on weekends?
No, sir, only Monday through Friday.
Okay, then you can serve it on weekends, so you can keep your work.
Okay.
You check in at 6, on or before 6 o'clock every Friday, you've got 27 days
Yes, sir.
to do it on successive weekends.
Yes, sir.
And you're going to begin this coming Friday.
Sir.
Thank you,
Weekend after
Judge.
Thanksgiving,
Sir,
the weekend after Thanksgiving, this Friday.
this weekend.
Okay, just making sure I understand.
No, yeah, this weekend.
This weekend.
I just,
Sure, it's been cool.
this is the kind of thing that's not even a question. This is clear that this is most serious and disturbing. And how you thought that this was going to solve any kind of relationship problem. It defies imagination of any reasonable person. And it wouldn't be, I wouldn't be doing my job if I didn't stand for something. And that is this kind of behavior deserved punishment. And I'm not going to be light on what I can do under these circumstances. I'm going to protect fetuses and pregnant ladies. I have a feeling that you regret what you did. I really do. But I wish you would have called me an hour before you went over and said, I'm about to do something foolish. Help me make the right choice, Judge. And I'd have helped you. Because this one is clear. This was a bad choice. And you're just lucky that is the child fine? Appears to be fine? Well, then thank our Creator for taking care of it, of the child. But it wasn't because of you. Are you going to take care of the child in your responsibilities under the law?
Yes, sir.
And nature?
Yes, sir.
And treat the child with love?
Yes, sir.
And the mother, y'all didn't get married or anything.
No, sir.
No. But nonetheless, are you going to respect the mother of the child?
Yes, sir.
Those are going to be the orders of the court. You got to report on it before 6 o'clock p.m. So.
All right, let's head across the hallway. We'll say good morning to Judge West.
And Ms. Hawkins, will your client waive the formal reading of the indictment?
Yes, Judge, we're going to plead to both counts of the indictment. Make this second, please.
Thank you. Mr. Spites, in cause number 25 DCCR 0023, you're charged with a third-degree felony offense of theft of property from September 14th of 2024. The indictment alleges you were previously convicted of felon in possession of a weapon, a third-degree felony, May 18th of 2023. And how do you plead to that charge? Speak up. And is that prior conviction true? Did you enter your plea of guilty freely and voluntarily?
Yes, ma'am.
And did you plead guilty because you actually did what they've charged you with? Yes, ma'am. I have here on the tablet some documents that have your signature on them that the state has marked as exhibit number 1. Before you signed these, did you go over them with Ms. Hawkins?
Yes, ma'am.
And do you fully understand them?
Yes, ma'am.
And do you understand, if I follow the agreement that you've made with the district attorney, that you will be waiving or giving up any right to appeal?
Yes, ma'am.
And it looks like the agreement that you've reached is for a 5-year deferred probation $500 fine, and there would be restitution that would be determined between now and when we came back for sentencing. Is that your understanding? Do you also understand that if you're not a U.S. citizen, a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law? State tenders number one.
No,
It's admitted. Is there any evidence that Mr. Spites is not competent?
no, Your Honor.
All right, sir, I'm going to find that you entered your plea of guilty freely and voluntarily. Find that you are mentally competent and understand the nature and the consequences of your plea. Find sufficient evidence to find you guilty. However, I'm going to reset your case so that the probation department can do a pre-sentence report. That'll give me more information about you, your case, and then we'll come back later for sentencing. You need to stop and talk to probation on your way out of the courtroom today, and she's sitting at that desk right over there. All right, thank you. See y'all back at sentencing. Ms. Holmes, I signed the dismissal in Ms. Renfro's case and told her she could go.
Yes, ma'am, I saw her. Thank you.
Thank you.
All right, we'll continue in the building. Judge Stevens has his next contestant.
I can say that
That's shot to the throat. That shot to the throat you just gave me. Yeah, thank you. All right, on Mr. Dixon. Well, it's just, just some things just have to be said, you know, that's nature. We don't tip the scales of nature. It's not the way our creator did planned, the way this should happen. Okay, Mr. Dixon, let's take care of you. Lance? 43-41449 is called the State of Texas versus Lance Shane Dixon, present with Mr. Burbank and his attorney and the state's attorney.
Judge, I want to let you know that the plan here is to plead to a lesser included offense. That would be sexual assault of a child. It is detailed in.
Is this a valid lesser included offense? Because I didn't. Okay, it has to be, since it's stated.
Yeah, the very first
as a
paragraph.
method of
Yes, sir.
committing the offense.
Yes, sir. And it would be our intent.
Is it under 22.011, the Texas Penal Code as alleged?
Yes, sir, it is.
Okay. Does the defendant waive a formal reading of the indictment and arraignment here? Can we proceed in summary?
He does, in your mayor, Your Honor.
Well, y'all went on or beyond, on the 2, 3, 6 paragraphs of methods of committing the offense, huh?
I was back in a different time.
In summary, this indictment alleges that from on or about October 1st, 2019, I keep getting a box that's trying to reboot and add and update things, and that's never shown before. And it's an odd looking one.
Yes, sir.
That from on or about October 1st, 2019 through on or about January 14th, 2020 in Jefferson County, Texas, committed the first degree felony of continuous trafficking of persons. Do you understand what you're charged with here? Among other allegations in this indictment, it states that you, in committing the offense of trafficking, that you knowingly trafficked a person younger than 18 years of age and caused the complainant to engage in or become a victim of conduct prohibited by Texas Penal Code Section 22.011, sexual assault. I understand that there's the agreement has been reached that you would be pleading guilty to the second degree felony of sexual assault. And
At this stage.
Which subpart? It's section 22.011 of the Texas Penal Code states that a person commits an offense of sexual assault if the person intentionally or knowingly A, B, or C.
Two. And just
Subpart C states causes the sexual organ of another person without that person's consent to contact or penetrate the mouth, anus, or sexual organ of another person, including the actor. Is that what the underlying circumstances are that the parties agree this, what occurred in this case?
No traffic.
Right. What the
No,
agreement
just-
is that it's
So I'm
between.
talking to sexual
Right.
assault.
Yes, sir. Yes, sir.
Yes.
And is that what you understand, sir? You were pleading guilty and true to beyond a reasonable doubt.
Yes, sir.
What's the punishment range here on this one?
220.
220, Judge.
Wait, an offense under this section is a felony of the second degree, except that an offense is a felony of the first degree if certain circumstances occurred which are not applicable here. So under section 22.011, subpart F, this states an offense under this section is a felony of the second degree, unless otherwise alleged, which it has not. Thus, you're facing a term of not more than 20 years or less than 2 years in prison. In addition, a fine may be assessed not to exceed $10,000. Do you understand?
Yes, sir.
The agreements further reached that would be whatever sentence shall not exceed a cap of 10 years in prison. So you're looking at no less than 2, no more than 10 years confinement in prison. I guess you could be placed on deferred or unadjudicated probation as well as regular probation. Is that right?
You can do right.
I don't think you can do right there.
You sure?
You can do.
On sexual assault, not aggravated sexual.
Sexual assault of a child.
I'll check, Judge.
We can't. Probation.
Listed under A 42A.054 that you're limited under A5. So you cannot provide regular probation. You can do deferred.
Okay. You understand
Yes, sir.
your options? If I follow this, and this can be up to, again, the cap is up to 10 years in prison or probation. And so what we're going to do is have a pre-sentence report prepared, come back later, everybody adds information, and the court will make its final decision. If I follow this agreement, you have no right of appeal of your case. Do you understand, sir?
Yes, sir.
How do you plead to this lesser included second degree felony of sexual assault? Guilty or not guilty?
Guilty.
Are you pleading guilty voluntarily? That is on your own free will and because you are guilty?
Yes, sir.
Show you what's marked as State's Exhibit 1 here. Did you sign this document voluntarily, understand it, discuss it with your attorney? Are the contents all true and correct?
Yes.
Yes, sir.
State's Exhibit 1 tendered into evidence and
No
without objection admitted. Among other things, this states you are mentally competent to enter your guilty plea. It's freely and voluntarily made. You know what you've been charged with. The indictment has been read. You've read it. You understand it fully. You were guilty of the crime charged in any lesser included offenses such as this sexual assault. You were giving up your rights to a jury trial, the right to appearance, confrontation, cross-examination of witnesses. You were totally satisfied with the representation provided by your lawyer. All true. So help you God.
Yes, sir.
State's Exhibit 1, part of the record for all purposes. We're going to order a pre-sentence report, return back.
Judge, if you want to try to get this done before the end of the year.
Do we?
No, I have something.
No.
That
First part in January,
Okay.
Middle of January, that's going to be fine.
first and middle, 10th of after.
I can do, January 12th.
Good. Set within. I gotta print all the stuff on the face of the indictment, the lesser included. All right, we are resetting until January 12th for sentencing. Please get a reset.
All right, let's get out of Texas for a little bit. We'll go back to Florida, but let's spend a little time with Brantley Clark. He has a parade of zebras. Looks like some felony hearings this morning. Let's see what's going on.
It's 2100. We're entering a plea of not guilty today. There's a misdemeanor offer, but we want to make sure we don't mess up the immigration status.
Okay. Well, let's set this for December 18th, no, January 22nd at 9 o'clock, and then we'll go from there. Okay? This is O'Dane Palmer, 25 CF 2100.
Okay. Justin Miller.
January 22nd, wouldn't it? Didn't we do January 22nd?
Yes, Your Honor.
January 22nd
The January
at
date.
9 o'clock.
Got Mr. Miller in case 25-3210. We'll be entering a plea offer. Entering a plea no contest. On the new law case is 2 felony batteries, priors, and then in case number 25-1938, it's a misdemeanor VOP, and 25-3240 is also misdemeanor VOP. Entering adjudication withheld, 18 months probation, court costs and fines of $1,028. He'll have his jail credit awarded, 50 hours public service work, the direction of the assigned probation officer at the minimum rate of 8 hours per month, $20 cost of supervision, drug and alcohol evaluation counseling is recommended, 0 tolerance for the use of controlled substance, random urinalysis at defense expense, shall not be subject to testing for marijuana during the first 30 days. First random urinalysis service for drugs will serve as baseline. DMV may apply additional penalties, time served on misdemeanors, DNA sample, forfeit these items. Mental health evaluation counseling is recommended. Peaceful contact with victims. He'll complete batterers intervention program, and then he'll have VOP. The misdemeanor violation probations will be time served and revoked.
That's the agreement with the state.
Here we go.
All right, Mr. Miller, state your name, please.
My name is Justin Miller.
Mr. Miller, you just heard the announcement, Mr. Spitzer. Is that correct?
Yes, sir.
Is that your understanding of the agreement with the state?
Yes, sir.
Has anybody promised you anything different?
No, sir.
Are you under the influence? Any drugs or alcohol this morning which would impair your ability to enter the agreement or understand any of its terms and conditions?
No, sir.
I've been handed a plea waiver of consent form. There's the front. On the back, it's a signature over the defendant line. Is that your signature?
Yes, sir.
Have you had a chance to read that agreement?
Yes, I did.
Have you had a chance to go over your cases with Mr. Spitzer?
Yes, sir.
Have you had sufficient time to speak with Mr. Spitzer about your case?
Yes, sir.
Are you satisfied with your lawyer's advice and counsel?
Yes, sir.
Do you understand that by entering this plea, you're waiving your right to go to trial?
Yes, sir.
You're waiving your right to require the state prove the allegations against you?
Yes, sir.
You're waiving your right to have your attorney cross-examine the state's witnesses and contest their evidence.
Yes, sir.
You're waiving your right to present any defenses that you might have to these allegations.
Yes, sir.
You're waiving your right to subpoena your own witnesses to come to court and testify on your behalf.
Yes, sir.
You're waiving your right to testify to remain silent at the trial, which would be a decision you'd have to make.
Yes, sir.
You're waiving your right to appeal anything but an illegal sentence.
Yes, sir.
Are you doing this for your own free will?
Yes, sir.
Mr. Miller, do you feel these pleas in your best interest?
Yes.
All right. And you understand if you're not a citizen of the United States, you may be subjecting yourself to deportation proceedings by entering the plea?
Yes, sir.
All right. I am going to accept the stipulation, find there's a prima facie case. I'm gonna find that Mr. Miller's pleas are freely and voluntarily made after consultation with his attorney. Case number 25 CF 3210. He's adjudicated guilty of 2 counts of felony battery.
Your Honor, should be adjudication withheld.
Oh, adjudication of guilt is withheld. He's placed on a term, is that 18 months? Term of probation not to exceed 18 months on each count. He's ordered to pay fines and cost of $1,028. There's no restitution applicable in the case. He must complete 50 hours of community service work at a minimum of 8 hours a month to the Bay County Work Program. I'll give the Florida Department of Corrections the discretion to amend that to at the direction of a probation officer. His cost of supervision will be $20 a month. Within the next 30 days, he must undergo a drug and alcohol evaluation, follow all recommended counseling, zero tolerance for use of any controlled substance not prescribed by a treating physician. He'll be subject to random UAs at his own expense. Department of Highway Safety and Motor Vehicles may apply additional penalties. If he's required to give a DNA sample, he must submit one. He'll forfeit all seized items. He may only have contact and peaceful contact with the victims. And he must enter and successfully complete the batter's intervention program. And all the misdemeanors are VOPs. Is that correct? Or is there a new? They're all, okay, on the 25, 1938 and 25, 3240, both MM. His probation is revoked. He sentenced the time he served in the Bay County Jail, giving credit for that time. And I assume he's already been adjudicated guilty of those batteries. They'll all run concurrent with each other. Mr. Miller, you have 30 days to file your notice of appeal. If you wish to appeal your judgment sentence, if you'd like to have an attorney to represent you, you can't afford one. One may be appointed to represent you at no charge. Good luck to you, sir. You'll need it. Ma'am?
Should have been mental health evaluation.
Oh, I did the batter's intervention program. Within the next 30 days, he must undergo a mental health evaluation, follow all recommended counseling. Okay. All right, mental health and follow all recommended counseling. I believe you. You'd have to hand it back to me. I did it.
We'll step right over here and talk with probation. Okay. Jonathan Peters. Mr. Peters approaching in case 25-2904. We're going to enter a plea of not guilty today.
Okay.
I would ask for the December date because the state hasn't made contact with the alleged victim yet. So just keep it on.
December the 18th at 9 o'clock. Hatcher?
May I handle one case real quick?
Yes, sir.
Your Honor, I've got to go over to Okaloosa this afternoon, so I have a case on your afternoon docket.
Okay.
State of Florida versus Kyle Van Tonder, 252763.
What's the last name?
Van Tonder.
I got you.
Your Honor, we've entered a written plea not guilty on his behalf. I would go forward with that and ask for the matter to be set to pretrial. Mr. Sullivan's given me a plea offer. I'll speak with my client between now and then. Hopefully we can get this case resolved.
January 13th at 1:30?
Yes, sir. Thank you, Judge.
Yes, sir. Have a safe trip.
Michael says in the chat it's a Florida day or a Florida Monday here on TCF. Yeah, and in Texas, in our continuing efforts for 9 to 11% more, Judge Boyd. Let's go there.
Versus Laura Cruz. Can I have parties announced?
Ashley Jones for the state.
And Johnny Cisneros for Ms. Cruz.
All right. And you're Ms. Cruz? And Attorney Cisneros, who do you have with you?
Oh, this is Leticia. She's I'm mentoring her. She's going to go to law school,
Awesome.
and I'm mentoring her. So
Welcome.
Thank you for having me.
All right. So we are here. The defense has filed a motion to remove the GPS device. State, are you in agreement or disagreement?
Your Honor, we have spoken with the defendant in this case, and we have the state objects.
All right. Then I'll take whatever evidence either side wishes to present.
Judge, what we have is that this has put a huge burden on Ms. Cruz. This case allegedly happened 13 years ago. She just found out about it when she was arrested on.
Wait. This case is from 13 years ago?
Your Honor, that's when the alleged assault occurred. The outcry didn't come until last year.
The outcry came in April the 10th of 24.
Okay.
And my client, Your Honor, has no contact with the complaining witness, doesn't know where she lives, doesn't know where she works. She's now about 18, 19 years old, doesn't know where she lives, where she works, has no phone numbers, has no contact with her. The only contact she had was this year was in April, where there was a family party and the complaining witness was there and with her and all the family members, and they're talking like if nothing happened and everything like that. And in fact, we have several pictures that we have tendered to the district attorney's office to show that nothing, there's no fear on behalf of the complaining witness of my client. There's nothing. And we're just asking for the GPS to be removed. Her boyfriend needs surgery. He can't have surgery because she's the one that takes care of him. And we're waiting for something to help her take care of her boyfriend. And it's just putting a huge burden on her and her family. And again, well, we're here for that.
All right, so it wasn't on the docket. So now I see why it's 13 years, because I just saw what the charge is.
Your Honor, it is on the docket. It just didn't show.
No, that's what I'm saying. It didn't make the docket sheet, but you all are actually on the docket for
Yes,
today according to Odyssey. But I had to look it up to see what
Yes,
the
ma'am.
charge was. That's, now I understand why it's been 13 years.
Yes, ma'am. And just to correct one thing, I do believe that the party that defense is talking about was April of last year, which is what sparked the outcry.
Okay, well, there was pictures from a year before and other pictures that we have
All right.
that just putting a big hinder on my client.
All right. So State, do you have any objection to tracking?
Your Honor, again, just on behalf of the complainant and their fear of their safety, the state would just object to changing the GPS as it is right now.
All right. So what the court will do, because of, you're saying she has medical
Yes, ma'am.
with her boyfriend?
Well, and she has an adult child that's severely handicapped that she takes care of. Sometimes she has to take him to the doctor and do other things. And it just puts a big burden on her because we have to call the GPS people to get permission for her to go. And then they tell her, well, you got to get permission from the judge. And it's just hindering her from doing a lot of things that she needs to do.
All right, what I'm going to do is I'm going to alter amend conditions to include tracking. If you all will put in the order, if there is a certain area you do not want her to be in. And I know you already have the no contact order. You're not allowed to have contact. Do you understand?
And Your Honor, especially at this time, I do believe the defendant was not having it is that it's their own. It might be just easier to keep it without any area.
But what if she goes in the area?
My client's,
Okay.
and my client's been advised by me, Your Honor, that should this be granted, she's not to have any contact with her. If she runs into her at HEB or the restaurant or something like that, my client is to leave the premises or wherever she runs into her.
All right. And so what is it? No contact with the complainant and the complainant's family?
There's no contact with the complainant and any minor child.
Well,
Right, as of right now, Your Honor.
well, any minor child, Your Honor, I mean, she has grandchildren that she has to help take care of and stuff. The mother of the grandkids or of her grandkids is having to work and stuff. And it just puts a big burden on something that my client doesn't even know where this lady lives or has a phone number or where she works or goes to school. She doesn't know anything about her. Hasn't seen her since April of 24.
All right. And what's the age of the alleged complainant at the time of the alleged offense?
4 years.
All right. So this is what the court is going to do. The court will alter and amend conditions to include tracking. There's to be no contact with the complainant and no unsupervised contact with minors. And I have your next court date in the system as December 4th. And that at that time, an offer is due.
Okay.
All right. And I'll put this in the system and then, do you need another reset form?
I don't need a reset form, Your Honor.
Okay.
think it's already on my calendar anyway.
Okay, all right, thank you.
Thank you so much.
You're
It would be
welcome.
excused.
And let me put this in the system and then if you need a copy.
Okay, thank you. Thank you, Your Honor.
Thank you.
You're welcome, thank you.
All right, we'll stay in Texas. Go back to Judge Stevens, new contestant.
CR 277 and 1379. And you are Marcus Avila?
Yes, sir.
And who is the lawyer for the state?
Nisha. She's still adjusting to the tablets.
Last one. Johnson, you got 1 o'clock.
I'm gonna move forward and while they're working on that.
Yeah.
Does the defendant waive formal readings of these indictments and the arraignments? Can we proceed in summary?
Yes, Judge.
In summary, in 277, and this indictment alleges that on or about February 3rd, 2025 in Jefferson County, Texas, you committed the state jail felony of fraudulent use or possession of identifying information. Do you understand what you're charged with?
Yes, sir.
State jail felony?
Yes, Judge.
If convicted, you face no less than 180 days up to 2 years in state jail and a fine up to $10,000 can be assessed. Do you understand?
Yes, yes, sir.
25 CR 1379. In summary, this on paragraph 1, is that all we're going on?
Yes.
Alleges that on or about November 18th, 2024 in Jefferson County, Texas, you committed the second-degree felony of illegal possession of methamphetamine, a controlled substance. Do you understand what you're charged with there?
Yes, sir. Yes, sir.
If convicted of a second-degree felony, you face no less than 2 nor more than 20 years confinement in prison and a fine up to $10,000 can be assessed. Do you understand?
Yes, sir.
What are the agreements?
Judge, for the state jail felony, which is 0277, month state jail, written CC with 1379, which is 7 years TDC.
All right. Agreements have been reached in these cases, beginning with 277. Mr. Avila. Here. You would be pleading guilty, sentenced to 18 months in the state jail to run concurrently with the illegal possession of controlled substance 1379. Is that your understanding of the plan?
Yes, sir.
If I follow that, you have no right of appeal of your case. Do you understand?
Yes, sir.
Hey, Lacey, this thing keeps showing up. It wants to, I'm gonna snooze it.
Yeah.
I'm gonna snooze it for an
Yeah,
hour.
just snooze it. And when we get done in the court today, Judge, I'll.
Thanks. In 1379, the agreement. Hold on. It's circulating. It's circling around, it's trying to land, and it is lands. This is a second-degree felony, again, which means you face no less than 2 nor more than 20 years confinement and up to $10,000 in fines, and the agreement is you will be pleading guilty, sentenced to 7 years in prison to run concurrently with the preceding case. Is that your understanding of the plan?
Yes, sir.
If I follow this agreement, you have no right of appeal of your case. Do you understand?
Yes, sir.
How do you plead to this illegal possession of a controlled substance, methamphetamine, second-degree felony, and 1379, guilty or not guilty?
Guilty.
Are you pleading guilty voluntarily and because you are guilty?
Yes, sir.
I show you in each of these cases what's marked as State's Exhibit 1. Did you sign those documents voluntarily, understand them, discuss them with your attorney? Or are the contents true and correct?
Yes, sir.
State's Exhibit 1 tendered into evidence and without objection admitted. Among other things, each of these State's Exhibit 1 matters in each case state similarly that you have signed and acknowledged that you are mentally competent to enter your guilty pleas. They are freely and voluntarily made. You know what you've been charged with. The indictments have been read to you. You've read them. You are guilty of the crimes charged in any lesser included offenses. You are giving up your rights to a jury trial and the rights to the appearance, confrontation, cross-examination of witnesses. Totally satisfied with the representation provided by your lawyer. All true, so help you God.
Yes, sir.
State's Exhibit 1, admitted in each case without objection.
Yes, Judge.
State pre-sentence reports waived?
Yes, sir.
I'm going to follow these agreements, sir, and find in each of these two cases, 25 CR 277, the state jail felony of fraudulent use of identifying information, and 25 CR 1379, illegal possession of a controlled substance, namely methamphetamine, a second-degree felony. In each case, you have pleaded guilty voluntarily. You are mentally competent to do so. You understand and appreciate the consequences of pleading guilty. There's sufficient evidence supporting your guilty pleas from State's Exhibit 1 admitted here to find you guilty beyond a reasonable doubt.
Yes.
And you have pleaded guilty in each of these cases
sir.
voluntarily,
Yes.
knowingly, intelligently, because you are guilty.
Yes.
I now find you guilty beyond a reasonable doubt in each of these cases. I'm following these agreements. In 277, you are hereby sentenced to confinement in the state jail for 18 months. And in 1379, you are hereby sentenced to confinement in the institutional division of the Texas Department of Criminal Justice to serve a term of 7 years. These sentences shall run concurrently. Do you understand what has happened today, sir?
Yes, sir.
Anything else to add on this? Thank you. We'll recess on those two.
Had something new pop up in my feed just now that we haven't gone to before. This is Lubbock County, Texas. This is the magistrate court. Let's give it a look. Let's see what's going on.
Mr. Ariano, you're here today to enter a plea, and we're handling your plea over this Zoom proceeding. Is that all right with you for us to handle your plea over this Zoom?
Yes, ma'am.
Fingerprints were taken from you there at the facility for us to use as your signature on your paperwork today. Is that all right with you for us to use your fingerprints as your signatures?
Yes.
And have you been able to go over all of your paperwork prior to court with your attorney, Mr. Taha?
Yes.
And did you understand everything and sign everything with your fingerprint today freely and voluntarily?
Yes.
Okay. Now in this County Court 2025 criminal case 2648, you're charged with a Class B misdemeanor offense. And do you understand the full range of punishment that you are possibly facing?
Yes.
There was also the plea offer that has been made to you. Other than the offer, has anyone promised you anything in order for you to enter any type of plea today?
No, ma'am.
And Mr. Taha, do you feel like that Mr. Ariano understands his rights in the proceedings as well as his charges?
Yes, Your Honor.
All right. Then, Mr. Ariano, before I proceed, let me just verify. How do you spell your last name?
A-R-E-L-L-A-N-O.
Okay. I just wanted to make sure it was correct in the paperwork. So in this county court case ending in 2648, you're charged with a Class B criminal trespass of a building or property committed on or about October 9th of 2025. And how do you plead to that charge?
Guilty.
I will accept your plea of guilty and find that you are guilty of this offense. I'm also going to follow the agreement that you made today, and I will now assess your punishment in this matter at 40 days in the Lubbock County Detention Center with your court costs of $280. You're going to receive all of the jail credit that you have in your case towards your sentence. That jail credit is showing me a total of 40 days from the following dates. October 9th of 2025 to the present time. And does that sound like your correct jail credit?
Yes.
So your jail time and your court costs are running concurrent with each other as permitted by law. So you are getting jail credit towards those court costs that you're owing. And you're not going to be required to repay the county for any attorney fees as costs of court based on the original indigency finding made when your attorney was appointed to represent you. So having said all that, that makes this a time-served matter. Was that your understanding?
Yes, ma'am.
And does this resolve everything that your client has pending at this time, to your knowledge, Mr. Taha?
Yes, Your Honor.
And is there anything further from the state in this case?
No, Your Honor.
Anything else from the defense?
No, Judge.
All right, then we will be adjourned in this matter at this time. Mr. Ariano, jail staff will get you released later today once they're able to process my paperwork there at the detention center. And you are adjourned from the courtroom at this time. And may leave or listen to the officer's instructions.
All right, that's Lubbock, Texas. Fairly routine stuff there, it looks like. Let's go back to Judge West.
And Mr. Benor's case is set for trial. This is 22-40828, Monday, the 1st of December. And what is the announcement?
Judge, we're ready.
Stage ready.
With regard to the issues that we began discussion of, and I gave some time for Mr. Gertz to be able to reach out with investigation on other complaining witnesses, has all that been taken care of?
From our standpoint, Judge, we've had no ability to get anyone to speak with us.
Okay.
So that's their choice,
Sure.
obviously, but we've made the effort to have that done.
So what I need to do then is prior to that Monday, make a ruling. We probably need just a little bit of time for them to.
I think one of the challenges I have, Judge, is I'd like to, what we had, just my recollection is what we had last time was essentially a proffer by an investigator, just proffering what other people said.
Right.
But I don't feel like we have the details, sort of police report level details from any of these allegations, if you will, so I guess I just feels like that would be discoverable, whatever the state has in their possession about these interviews.
Have there been any?
There are no written statements, Judge. We made, in fact, I don't know that we were even under an obligation to give as much detail as we gave. We gave you notice of these witnesses that they exist and the nature of what their testimony might be. But the short answer, Your Honor, is there's been no written statement.
And have they talked with just investigators, or have they talked with detectives from other agencies, or just within your office?
Just within our office,
Okay.
to the extent that I'm aware of, Judge.
Okay, so there aren't any police reports or anything like
Not
that?
that I'm aware of.
I think what I'm going to need to do, and I know I made some pretty detailed notes when we were here before, is make obviously the ruling on which, if any or all, I'm going to allow. And so, there's my notes, look at that. I don't know that I need, if there is no other. So there were 4, correct? We used initials. We had an initial of SM, which was a 2000 case, tummy tuck. There was some pretty detailed information that was given on that one. There was MN, which was a 1992 sinus issue with some other issues that came to light that time. And then we had a TK that I think had become now a TR from 2022. Also some details about that one. And then an RD from 2015 was a tummy tuck. Oh, and then one more, but that one hadn't been contacted back. In RL, is there any notation that one is, so, okay.
We've not had any subsequent contact with RL.
All right. So, if there is no other, if there aren't any other police reports, and the, do you want time early one day this week to actually have an argument, hearing? Do y'all just want me to make my decision based on what I have?
I think it'd probably be better to do it written by submission and let the court rule on it next week sometime.
Okay.
I don't have anything additional to add. I'm okay with the court just making a ruling.
Is that your phone?
The answer is yes. I'm okay with the court just making a ruling without any additional argument. Just make sure it's all completely off. Take it out, make sure.
Yes.
Okay, so what I'd like is if you guys will get that, anything written. I think, Mr.
I think I gave
You already did, I'm pretty sure. And so what I'll do, if you want to have anything to add to yours, you're welcome to do that. And then if you just want to do a response in writing, I would really like that, if possible by Thursday. Are you in trial this week? By Thursday of this week.
I'm not in trial now this week.
I'd like to make that ruling before the end of this week so that you all know while we're off next week what to be preparing for. Anticipate this will be the #1 trial, obviously. I think we've talked about that and making it special setting because of the age and the fact that we've already gone through it. So I want to make that ruling by Friday. So I'll be around. Obviously, I'm in trial, and I'll make that and give it to you guys by email or by an order. Okay?
Yes, Judge. Judge, the court has already ruled previously in a previous hearing subsequent to the trial that the court would allow this case to be off of YouTube. We just reminded the court of that decision that I believe was made a while back, and asked the court to do that once we begin trial on the 1st.
Did I?
I don't recall that, Judge.
Why would I have done that?
I believe.
I mean, you may have asked for it, but I don't remember saying that I would. I think if the complaining witnesses have an issue, then I would be, if I recall, I don't remember, I thought it was this case where I talked about potentially during certain testimony, blurring it out or blacking out certain things, but I don't, if you want to do something, a brief in writing, a short, something about what your request is and why, I don't recall actually or saying that I for sure would not do that. That doesn't, I remember maybe having the discussion, but I don't remember saying for sure I would.
And just I think the facts for this case are distinguishable from the typical case where.
Sure. I mean, I never put child cases on, and typically I primarily leave it up to a complaining witness or something like that, who's disclosing, private certain information. But I will take what you have to say into consideration. If you will also reach out to, I think the complaining witness, I mean, we had it on last time. If she's still okay with that, at least just shoot me an email and let me know, and then put whatever you need in writing, and then I'll make that decision when it gets a little closer.
Okay.
Anything else that you guys know of that we will need to address pre-trial on this one?
Not from the state judge.
Okay. All right, then I'll make that ruling again on those additional witnesses by Friday.
Okay.
All right, stay in touch with Mr. Gertz. He'll let you know when you need to be back. And then, Mr. Gertz, you have a Jonathan Zecaf.
Well, the next contestant comes up. Congratulations to Lindsay and to Michael, both hitting their six-month mark for channel membership. I appreciate the support that both of you have given me and the friendship. It means a lot, so thank you so much.
Jury selection on December the 1st. Announcement.
It's pleading to a lesser included.
Oh, it's right here. Gotcha. Hold on. Hold on. I need to look at too many things. DWS second. Okay. Let me get that pulled up. Mr. Gertz, will your client waive the formal reading of the indictment?
He will, Judge.
Mr. Galvan. All right, Mr. Zcaff, the state has elected to proceed. So it would be on the April 10th, our date, and then just one prior. So it would be paragraph 1 and 2, correct?
Yes.
So it's not really counts. Okay. So the state's elected to proceed on paragraph 1 and 2. It alleges that you committed the offense of driving while intoxicated April 10th of 2024. The indictment further alleges in paragraph 2 that you were previously convicted of driving while intoxicated January 16th of 2019. And how do you plead to that charge? And is that prior conviction true? Did you enter your plea of guilty and true freely and voluntarily? And because you did what they charged you with? I have here on the tablet some documents that have your signature on them that the state has marked as exhibit number 1. Before you signed these, did you go over them with Mr. Gertz? Do you fully understand them? And do you understand, if I follow the agreement that you've made with the district attorney, that you will be waiving or giving up any right to appeal? And it looks like the agreement is for a 1-year term in the Jefferson County Jail, but that would be probated for 2 years. You would be ordered to pay a $2,500 fine, follow all of the rules and conditions of probation. Also, part of that is that you would serve 10 days upfront time, and you would have the interlock device for that for the first year of your probation. Is that your understanding? I do want to make sure you understand that conditions of probation are up to me. If for some reason after that year, I feel like it would still be necessary for any reason, if there's been any hiccups or anything like that, it could still be ordered by me after that period, regardless of what you guys have agreed to. Do you understand? Okay. State tenders number 1.
We have no objection, Judge.
It's admitted. And sir, are you a U.S. citizen?
Yes,
And is there any evidence that Mr. Zcaff is not competent?
no, Judge.
So are y'all ready? Do I need to get a report? Are we?
We're
See-
ready to proceed. Judge.
All right, so I'm going,
And
is
then
there?
We have one caveat regarding the upfront time.
That's what I was going to get to. So what's that?
We're asking that the court allow him to do the 10 days on 5 successive weekends, starting on November 28th at 6 p.m., please.
Any issue with that? All right, so I'm going to find that you, again, entered your plea of guilty freely and voluntarily. Find that you're mentally competent and understand the nature and the consequences of your plea. Find sufficient evidence to find you guilty, and at this time, find you guilty of the driving while intoxicated second, a Class A misdemeanor. Sentence you in accordance with your agreement to a term of 1 year in the Jefferson County Jail, but I'm going to probate that, and you'll be on probation for 2 years. You're ordered to pay the $2,500 fine and to follow all of the rules and conditions of probation. You will be ordered to serve 10 days up front. That will start on Friday, November the 28th at 6 p.m. And then you will go every weekend until those 10 days, for 5 weekends until those days are served out. It's important that you're on time for that, 6 o'clock. If you're late, it could be a violation of your probation. Do not show up under the influence of anything. Some people think they show up, they're going to do whatever and get there and sleep it off for the weekend. Bad idea. You'll be right back in here on a motion to revoke your probation. You are required to have the auto ignition interlock device for sure for that first year. And then if everything goes fine, obviously that condition would go away as well. If you follow all of the rules and conditions and do everything you're supposed to, then for all practical purposes, your case here in court is over. You'll be able to serve that 1 year sentence while you're out on probation. The other side of that is if you violate any condition of probation, you could be brought back into court and you could be sentenced to that 1 year term that you've already agreed to. Do you understand? Yes, ma'am. I'm going to hand you the trial court certification. Shows that this was an agreement that I followed, and so you've waived your right to appeal. It is a long ways to go from here to there. You need to have a seat once I give you that document here in the courtroom. Probation is sitting at that desk right over there. She's going to call you up when she's ready to go over all of your paperwork. All right, good luck to you, sir. Thank you, Mr. Kurtz and Mr. Smith.
Michael, thank you for gifting a membership. Lindsay, thank you for gifting 6 of them. Unlike that streamer that we talked about in the pre-show today, I really appreciate all of you because I know that it's not the easiest world right now, especially when it comes to money. And it means a lot that you guys make the choice to spend your hard-earned money here on the channel in support of what we do. So always appreciated, never taken for granted, and I just want to say thank you so much. Let's go to Michigan. Spend a little time with Judge Middleton, or a lot of time if he gets on a story about a bridge. Let's see how this goes.
All right, it's time to get back to work. We've got several sentences, 3 set at 10:30 and 1 set at 11. The first case we're going to address is People versus Christy Elaine Benton. That's you?
Yes.
Miss Benton is here. She's charged with retail fraud in the 2nd degree and filed 251646 SM. She's represented in that case by Jordan Harden. She's also charged and filed 251723 with malicious destruction of property less than $200, and that is Ms. Harden. Mr. Bush represents the defendant in file number 241763, a retail fraud 2nd degree. The 2 matters that are set for sentencing are 1763 and 1723. 1 retail fraud, 1 MDOP. Another retail fraud was dismissed, I think, as part of this. Let me look. No, she pled in that case too. Miss Benton has been here a lot in the last couple of years, and I couldn't figure out. And the last time she was here, I gave her a large jail sentence, which resulted in her losing her job, but I felt it was appropriate. So she got out of jail, and here we are right back in it. So frankly, I needed some help. So I asked for a pre-sentence report, and one has been prepared by Matt Huff, who spent a lot of work on this. And I was embarrassed that I didn't realize the extent of your substance abuse issues. I didn't realize this was heroin and methamphetamine addiction. I thought it was just bad behavior. There are also other factors in here. Anyway, Matt has done an excellent pre-sentence report, which will be a place for us to start from. Ms. Harden, let me hear from you first.
Thank you, Your Honor. As the court has already indicated, Mr. Huff did a very thorough report to kind of highlight what's been going on in Ms. Benton's life as of late. The only update we would provide is that she does have employment. She's working at TH Plastics and has been there about a month. She reports that's going well.
I thought she told me she was employed again.
Yes, so she's working there. Things are going well. She's focusing on her sobriety.
What shift?
3rd.
Okay.
Her partner is here as a good support system, and he's referenced in her report as well as a stable and a constant in Ms. Benton's life. And I think the recommendation that Mr. Huff has provided tackles the things the court's looking in reformation as far as addressing the substance abuse issues, getting a plan for long-term sobriety, as well as addressing the history she's got of the retail frauds. So we're asking the court in our files to follow the recommendation of Mr. Huff. I think it's fair and appropriate. When I met with Ms. Benton at the jail, I believe she was serving time on a retail fraud, and these had occurred prior to that. So I don't believe this is a situation, and I could be mistaken, but it's my understanding these were all that occurred before that sentence. So since she's been released, there's been no issues, and she's appeared for court. She met with Mr. Huff. I think the report, like I said, highlights things that we need to focus on to help Ms. Benton become a productive member of society. And I think she's on a good start. So I ask the court to adopt Mr. Huff's recommendation today.
Mr. Bush?
Speaking with Ms. Benton, it's my observation that 30 days in jail was eye-opening for her.
There was forced sobriety. She didn't like it there, doesn't want to go back, but that's all what we're looking for. I think Matt Huff was on target here, that we need to focus more on reformation than punishment. And I do believe that the probation and the programs that are involved in the pre-sentence report are appropriate. I would ask the court to follow the recommendation.
Ms. Camfield, you've been here, I guess, about 8 months now, 6 months. Soon this will all be part of your history too. But we've been dealing with Ms. Benton for 4 or 5 years. And now you're here and learning this constituency. What's your thought regarding this case?
Thank you, Your Honor. I've had an opportunity to review the files as well as Mr. Huff's report and recommendation. And I note that, you know, people do struggle with addiction, and they struggle off and on and have periods of sobriety, and then they use again and leads to poor decisions. Reference the request for reformation. It looks like there has been reformation before. She did have probation in 2008 for retail frauds as well. And then she did subsequently serve the jail term this year that Your Honor imposed. I do think that given the honesty and candor of Ms. Benton with her substance use, and some of these she didn't even clearly recall, it's certainly not an excuse for criminal behavior, but an explanation as to why she may have come before the court again in recent years. So I think that the recommendation is appropriate. I would ask that the court follow it. In a circumstance such as this, though, I do find someone of her age and experience level and prior probation has the knowledge to recognize that using again may lead to more criminal action. I might give a couple more days jail up front, or some community work service as part of the reformation. She did just serve a pretty lengthy time, so that may have been enough, but community service I think would be appropriate. This does entail a malicious destruction of property as well as retail frauds that have made companies and essentially then their customers victims when retail fraud occurs and prices rise. It goes to the community as a whole. So I just think other than that, the recommendation is more than appropriate.
Mr. Huff, you drew this tough assignment. And I think maybe it's your first time meeting in depth with this defendant. As everyone said, we're going to focus on something, trying to stop the behavior. I'm almost more concerned about the malicious destruction charge than I am the retail frauds. It's weird. She's in this car, which is reported as stolen, and it's reportedly stolen from her current boyfriend.
That's correct.
So he had reported the vehicle as stolen, and she was driving it, and she had a child in the car, and his son pulls up behind her to block her in to get the car back, and then she allegedly bashes into his Mercedes a few times. He realizes there's a child in the car, and he moves so she can get out. Now, she and the person that reported the car stolen are back in a relationship, and so it probably isn't exactly stolen. But smacking into his car with that car wasn't a good plan. I'm going to ask you about that, Ms. Benton. Anyway, for a history lesson, when I was prosecutor, I started the embezzler treatment group. Mr. Bush remembers it in its original form because I kept having embezzlements by women and retail fraud and property crimes, credit card fraud, NSF, retail frauds repeated. There was a common theme in that they had childhood trauma that was not addressed. So the embezzler's treatment program was originally primarily set up for women. And I used it a lot when I was the prosecutor, and I felt it was an excellent program. When I became judge, other people were less committed to it. The circuit court didn't use it. And it was for circuit court embezzlements, large $20,000, $30,000 embezzlements. There's a reason why that happens. So we've resurrected it through the court, district court, not community corrections. And it's available. So that's going to get at the root of the question. What I did not understand is the depth of your addiction. You're always so polite, so respectful, so quiet. So I mentioned one time someone paid all your fines and costs, then you just go out and do it again. And I couldn't figure out why you kept doing it. Well, there's two answers: addiction and childhood trauma. Mr. Huff, thank you for your report. Anything you'd like to add to it?
I would just, above what the report says, I would just say that, it looks like Miss Benton, most people get a handle on their addiction or their problematic behavior earlier in life. But I think Miss Benton, from speaking with her, is genuine about where she wants to be. I think she's put forward the vehicle, so to speak, to get to where she needs to be. And I think the 30 days in jail up front was enough to get her attention. Probation would be a good opportunity for some extra accountability over the next year or so to make sure that we just cement into her life a good foundation.
Miss Benton, what would you like to tell me?
I mean, pretty much everything that he says. Jail was a definite wake-up call. I mean, it's embarrassing. I think I just, I want to get over the substance abuse, and I just think probation is going to keep me held accountable to be able to get there.
I think so too. What were you doing when you were bashed into this kid's car with your boyfriend's car?
Well, I mean, he had pulled up behind me, but I never bashed into it. There was a backup cam in the car, and I did have a little girl with me. And he was parked far enough behind me that when I backed up in a little bit at a time, I never backed into the car.
Well, did your car hit his car?
No.
Pled no contest to that charge. The case I sent you to jail for, I did in August of 2025. It occurred in 2024. I sent you to jail on August 25th for 30 days. The MDOP is listed as having occurred on August 4th. So that was before you went to jail. The retail fraud in 1763 is listed as 6/8 of 25. And the other one is 6/28 of 25. So these occurred while you were on bond on the earlier one, but before you went to jail. So I gave you 30 days in jail. Then these things came up. Now, what do I do now? Matt, as far as I can tell, with all of this, she only has 1 day of jail credit. Is that correct?
It's a little bit sticky in regards to what you want to consider for, I think you have a lot of discretion in this situation. Because she was placed in probation, bond wasn't set in these, or wasn't posted in these until a few days before she was released from custody on the 30-day charge that she was already serving. So, there could be some credit, so to speak, because she was released and there was a bond set. But
Okay.
essentially, those 30 days were set on the other case.
All right. Well, I'm gonna do the probation in the retail fraud case. I organized my judgments so well that I don't have any general judgments. But I'll use this one. I have a couple. I have 2 left. In the MDOP case, 251723, I'm going to order 1 day as a no contest plea. One day credit, 1 day, 0 fines and costs. Concurrent with the other cases.
Which file was that, Your Honor?
That was in 251723. She pled to retail fraud second in 251646. She pled to retail fraud second in 1767. And I don't need to put her on probation on both of those cases. We're going to do the probation on an offense that has a 1-year maximum.
Which file is that, Your Honor?
The next one we're going to address is the retail fraud second that you represent her on, Mr. Bush.
And she pled to retail fraud third in that file.
Third, that's what I've marked here. And except I can't read my own writing, but yeah, it's third, 1767. So I'm going to do the probation on the 1-year offense. One 767. One 763. I'm gonna also do 1 day jail credit, 1 day. concurrent with the other retail fraud, which is 251646. There is restitution, which will be included. One of the reasons why I never got clued into the addiction was that she was always working. She had some difficult jobs. Seems like she worked at Middle Technology, she worked somewhere else. And so I thought, well, so it didn't flash a red light. We're going to do the probation in Miss Hardin's case, 251646. Laura, could I have some more general judgments? This is my very last one. There's no sense making you lose another job. I think I made my point with the first 30-day sentence. And these all preceded that sentence. Not gonna do it. Well, I guess I will. I'm gonna do a 24-month probation, which means you're gonna be on probation for at least 12 months. I guess I'll order 91 days, credit 1, leaving 90 days to serve. Of the 91 days ordered, 90 are deferred. I'm not gonna put you back in jail, make you lose another job that you just got. But you're gonna do a probation. The fine is 0. There's a $75 crime victims' rights fee, a $50 state minimum fee. I'm just going to charge one attorney fee, $960 probation oversight fee. The restitution figure is in the report.
Do you need it separated by file number? Or are you comfortable with full files?
I'll just, what's the number?
It's
367? 362.
Yeah.
To Walmart and Myers. Thank you. All right, no drugs and no alcohol, substance abuse treatment as tested. This one actually has the embezzlers group on it. It's a very good class. I had 100% approval rating. The people that were in it all said it was very worthwhile. You can't keep going like this, Miss Benton. You're wise enough to know that. You got a stable influence in your life, which you didn't have. So I'm encouraged here. Let's add those numbers up. 125 plus 150 plus 960 plus 360, 230 is $1,597.30. Take $480 off it if you do this in a year, so you owe about $1,100. Is there a cost for the embezzler's class?
There is, I don't know exactly what the current rate is and if it's going to go up for the 2026 year.
Excuse me. At one time, I used community correction money to pay for it. But that was a different time. I was chairman of the Community Corrections Advisory Board for 35 years, and now Judge Stutzman has that privilege. But I want you to stay on the path you're on. And again, you're wise enough to know it. The other option is a long jail sentence and then death. Nobody wants that. Problem is you can't shop anywhere. You got kicked out of all the stores and then I barge. I guess you can shop at some stores, but you can't go to Walmart or Meijer's during the term of this probation. The community service idea was a good one, but you got enough to do. You're also to sign a release if we need information. All right, let's hope things get better from here. All right, Ms. Benton, you go downstairs and Matt will meet with you. Do you need these files, Matt?
I will need it.
All right.
Do you have any other 11 o'clock or is it just?
I have one 11 o'clock. I have.
All right. While they rack up the next contestant, let's go to Louisiana. Let's make that happen.
2025, time is 9:02 a.m. My name is Cheryl Renassa, serving as chair today. I'd like to ask for a roll call, please.
Ms. Renata?
Here.
Ms. Stapleton?
Here.
Mr. Prater?
Here.
Mr. Tibbetts?
Here.
Mr. Freed?
Yeah.
Madam Chair, we have a forum.
Thank you. We are at DOC headquarters in Baton Rouge. I'd like to get the staff here at headquarters. Please introduce yourself for the record.
Bill Cavalier. Jacqueline Thompson. Chiquita McCurdy. Carla Williams.
Francis Abbott. All right. Our first item on this morning's agenda is review and approval of the minutes from Thursday, October 30th, 2025. Those are included in your packets. Are there any corrections? All right, I'll entertain a motion to approve the minutes.
I'll make that motion. Second.
We have a motion by Mr. Prater, second by Mr. Freeman to approve the minutes from Thursday, October 30th, 2025 as presented. Is there any objection? Hearing none, those minutes are approved. And so we're ready to start our regular business. The next item is consideration of application for clemency or pardon. And we will allow public comment on requests before any action item. So our first remote location this morning is at Catahoula Correctional Center. Mr. Augustine, good morning.
Good morning, ma'am.
Are you, is there an officer in the room with you?
Yes, ma'am.
Hi, I'm Tanya Stevenson, the transition specialist.
All right, thank you, Ms. Stevenson, for accommodating us this morning. So, Mr. Augustine, would you introduce yourself, tell us your name and DOC number?
I'm Anthony Tyrone Augustine, DOC number 430160.
All right, Mr. Augustine, I'm just going to read some identifying information into the record. I'll ask you to verify if it's correct, and then I'm going to turn it over to Mr. Prater, seated to my immediate right. Your case has been assigned to him, so he'll take it from there. You ready?
Yes, ma'am.
All right, Mr. Augustine, you're here this morning seeking a commutation of your sentence. You were sentenced in the 12th Judicial District of Boyles Parish in August of 2000 for a manslaughter conviction. You received a 40-year sentence. You do have a good time date, which is December 23rd, 2033. Is that information correct, sir?
Yes, ma'am.
All right, Mr. Prater.
Okay, Mr. Augustine, how are you today?
I'm okay, sir. How about yourself?
Okay, I'm doing good. I'm doing good. Thank you for asking. Okay, we've got a number of people here that are in opposition, and we'll get to those in just a minute. But what we like to do as a board, we like to find out a little bit about you and a little bit about your history since being incarcerated, how you've done, and what you think about the crime. And then we want to hear from somebody from Catahoula there, if there's anybody there that would be willing and knowledgeable to speak about your behavior at the institution. So to begin with, Mr. Augustine, would you tell us what got you put in jail and what you think about the crime and what you've been doing since then?
Well, February 2021, I committed a horrible crime that, I wish I could take back, but I took the life of a mother, a daughter, a sister, a friend, and I hold myself accountable for the actions that I have done. But since my incarceration, I have taken numerous classes, such as substance abuse, anger management, cage and rage, thinking for a change. I have several Bible courses at colleges that I've completed and graduated from, GED. But like I said, I'm holding myself accountable for what I have done, and I have worked hard constantly. I'm still working daily to become a better person, a better man, a better brother, a better father, a better friend,
Okay. All right. Well, that pretty well wraps up your statement. You've covered all the high points of what I wanted to hear. Let's hear somebody from Catahoula. Who's in the room there with you? I'm sorry, I missed the name.
Tanya Stevenson, the DOC transition specialist.
Yes, ma'am. Do you know this fellow very well and how he's behaved since he's been there, and how long has he been there?
I'm not sure how long he's been here, but he has no behavior problems. He was a trustee here at the main facility, but he's at the parish jail where he is a trustee there.
Okay. All right. Well, thank you. I appreciate that information.
You're welcome.
Okay, well, let's move on now to those folks. We don't have anybody speaking on your behalf that have signed up to speak, but we have a number of people to speak against this request for commutation of your sentence. And so we'll begin. We have three people that will be speaking. We have Kia Greenhouse Allen, we have Cheryl Lewis, and we have Casey Greenhouse. They will be speaking. Now, there's a number of people that are here in attendance, and I don't know if you can see them or not, but it's J-Nex Greenhouse Jr., LaShawn Dixon, J-Nex Greenhouse Senior, Marie Jacobs, Chiquita Greenhouse, and Kim Greenhouse are also here, but they will not be speaking. They're just here for support and or support of each other, I would say in opposition of your request. So between Kia, Shara, and Casey, I will let y'all decide who will be first. When you speak, would you go to the podium? Please speak up so we can hear you good here at the board and on the microphone, and tell us what you have to say as far as your opposition. So whoever would like to go first, please introduce yourself.
Hi, I'm Sheree Lewis.
Okay, and let me apologize. I'm sorry, you were on Zoom, and I was introducing the folks that were here also. Yes, ma'am, you're on Zoom, and introduce yourself again.
My name is Sheree Lewis.
Okay.
And I'm Sabitra's best friend.
Okay, and tell us why you're in opposition for this.
Basically, because and I hear when he says that, yes, he want to change, that he changed and becoming a better person. But on the other end of it, he gets a second chance. Like he gets a second chance at life or whatever. My friend don't get a second chance. And he was selfish. I mean, he took a selfish move. You took her because of being selfish. And you left her child there with her. and yet you think you deserve another chance, which, no, I'm not God and I'm not doubting that, but I'm just totally not for it. No.
Okay. All right, Ms. Lewis, we appreciate you taking time to give us your thoughts on this. Ms. Allen or Ms. Greenhouse, who would like to go next?
I'll go next. Hello, my
Okay.
name is Kia Greenhouse Allen. I am the cousin of Sabitra Allen. I wrote a statement. I would like to express my strong opposition to the potential parole of Anthony Augustine for the murder of Sabitra Greenhouse. His actions not only resulted in the tragic loss of an innocent life, but they also left a lasting void in the lives of her daughter, Casey, and our family. Sabitra was murdered in her parents' home, a place that should have been a sanctuary. With this brutal act, Anthony robbed his child of her mother, leaving her to grow without the love and guidance that every child deserves from their parents. This senseless act of violence not only affected the victim, but has had a profound and painful impact on our entire family. Anthony does not deserve a second chance in society. His crime was not just a moment of anger. It was a calculated decision that shattered so many lives. I can never forget the words of the priest at her funeral. He stated that these were not the actions of a man, but that of a beast. The consequences of his actions are lifelong and cannot be undone. I urge you to deny his request for parole, as releasing him would bring injustice not only to the memory of Sabitra, but also to our family and the community that continues to suffer from this loss. Thank you.
Okay, thank you, ma'am, for taking time to be on Zoom with us, and we'll continue on then with the opposition. Now, Miss Casey Greenhouse, who is here at headquarters. Miss Casey, would you go up, Miss Greenhouse, would you go to the podium? There you go. Introduce yourself and tell us what's on your mind.
My name is Casey Greenhouse. To the honorable members of the Louisiana Clemency Board, my name is Casey Greenhouse, and I stand before you as the daughter of Sabitra Greenhouse, who on a crime was committed against on February 21st, 2000, at the age of 18, by my biological father, Anthony Augustine. I am here today because my father murdered my mother. I was only 6 months old. The story I have of that horrific day is that my mother was sitting in the same room with me, working on her schoolwork so she could graduate high school and create a better future for the both of us. I was told she was young, hopeful, and determined. She was doing everything right, working hard for her life and for mine. But all of that was taken from her when he died. I was left in the room beside her lifeless body. I was found only because my aunt unexpectedly became ill at school and had to return. I cannot imagine how long I would have remained in that house, along with her if my aunt had fallen ill that day. That is how my life began. Now with safety, now with love, with violence, trauma, and a state of parents. My 6-month-old life began with the loss of both my parents because of his choices. I grew up without a mother and without the father who should have protected me. I spent my childhood wondering what my mother's voice sounded like, what her laugh sounded like, whether my smile looked like hers, whether my strength came from her. There was, and but I would never know because she was silent before I ever had the chance to remember her. My mother never had the chance to record videos, take pictures, or leave behind the way people do today. One of the most painful of many things I grew up with was the longing to hear my mother's voice. I would wonder what she sounded like, and then it would hit me. At least he still has a voice to this day. Yet my mother remains silent and forever will remain silent. No videos, no saved messages, nothing. I grew up watching other children make Mother's Day wars, but I had no one to give one to. I watched other girls have their hair brushed by their mothers, get help picking out dresses, get cheered for school sports graduations. I never had any of that because I was robbed from my mother. She wasn't there for any birthday first days of school, my birthday, my heartbreaks, my first job, my college applications, my adult decisions, any milestones that should have been shaped by my mother's love. She should have been here. She should have been there for my wedding one day. She should have been there to help me prepare for motherhood when the time comes. She should have had a chance to be a grandma, but she won't, because that was taken from her. Every single holiday, celebration, and ordinary day has been marked by her absence. I grew up emotional with anxiety, sadness, and a deep emptiness that words can barely describe. My entire identity was shaped by a crime I did not choose, a loss I could not stop, and a moment I was too young to remember, but will spend the rest of my life feeling from. Ag did not just take my mother's life, it destroyed two families. My grandparents, aunts, and uncles raised me. Their own three walking on eggshells, so they didn't speak out of anger about my father. For 26 years, emotions, trauma, and unspoken pain were bottled up so that they would not hurt me further. They had to comfort a crying baby one morning, their murdered daughter and niece. No family should ever endure that. His family suffered because of his choices. They lost him as well. This was not just a crime against one person, it was a wound that spread across generations. In 2016, I received a letter, and in that letter, there was no apology from my father. No explanation, no accountability. Nothing that acknowledged the lifelong pain caused by your choices. Wrote that you love me, but I must ask, how could you love me, left me alone in a home with my mother's lifeless body? Why was the mercy in that letter for me? Greater actions. There was not a sense of remorse to that day that could be sensed at any point in that letter. How could you claim you love me while abandoning me in the darkness? Most terrifying moment a child could ever experience. Growing up when I struggled with depression, while wondering why not me instead of her? And even worse, I feared that when you got out, you might come back and finish what you started. That fear existed and continues to exist because of what you did. How can I form a bond with someone who never cared about me from the beginning? How can I trust you? How can I open my life to someone who hurt my husband in front of me and abandoned me immediately after? You love me so much, why did you just walk away from the relationship? I think you choose freedom and raise me like a father should. Instead, you chose violence. You chose this. You chose to destroy our family and the future I should have had. And now we're here. For your child, your daughter, forced to stand before a clemency board, begging, pleading, fight for her mother because of the actions of her own father. I'm pleased to agree to your release or to do any kind of bond with someone who never cared about me from the beginning. Someone who robbed everything that mattered the most in life. That is not love. Today, the man who caused all of this pain is asking for clemency, asking for mercy, but I asked this board, why was the mercy for my mother? Why was the mercy for me? The 6-month-old baby left crying beside her body. Why was the mercy for either of our families who have carried this trauma for decades? Mercy was never granted to us, to her. Why should it be granted now? Where was the clemency when she was carried by 6 while you were still breathing and had opportunity to be judged? Clemency cannot bring my mother back. It cannot restore the life she was building. It cannot give me the childhood I lost. I never heard, or the memories I never got to make. Instead, her questions destroyed our created generational trauma and forced me to lifetime and I answered questions. For 6 years, I've lived an emotional roller coaster, begging, pleading, and fighting for justice for my mother, because the person who should have protected us chose not to. This has shaped our life. And today I speak it to honor what we lived through and ask for justice that reflects that reality. Great mercy, not be justice. It'll be different to the lifelong consequences of his choices. Clemency cannot undo what was done. It cannot bring my mother back. It cannot give me the chance to hear her voice, to hug her, to know her love. Granting clemency in this case would not be just. It would erase accountability for a choice that was both selfish and irreversible. I have lived every single walking day with the weight of this tragedy. For all these reasons, I stand before you, requesting you to honor my mother's life, honor her dreams, Honor the silence she left behind, a silence created by violence, not choice. Let justice remain firm, because of mercy, courage, spoken once. Our faith from the earth support to deny clemency, that is the only mercy that remains. Let justice remain firm, because mercy was already stolen from us the day she was murdered. I would like to thank you all for this opportunity to stand before you and have this with my mother.
Good job.
Thank you very much for the reading that to us, and we also have been supplied that letter and read it, and I honestly had to take a break from studying my cases after I read that letter because that was tough. Well worded and good letter, so thank you. And while I'm talking to you, I'd like to give a special applaud or whatever to your grandparents, the ones that raised you, stepped up for you. You had wonderful sports. Okay, back to you now, Mr. Augustine. I guess you heard what your biological daughter had to say. And before we get into this part, which is the question and answer session from the board, but I'll lead that off. And then we'll see if they have any questions. Also, I want you to understand, we have read your file, so there's a lot of things that didn't come out in our interview. The fact that you are a first offender, I want to acknowledge that. This was your first felony arrest, that you did get your GED. You said that in your opening statement, but I saw that and I was particularly impressed by that one of your supervisors there in the work release, I believe it was, but the security supervisor there, did write a good letter since they've known you, which is the time you've been incarcerated, that you've been a model prisoner. And I know that, and I can look at your face and I can tell that you are remorseful in all of your statements. But also you need to know that the DA, the sheriff, and the sentencing judge were all opposed. And all of the victim family was opposed also. So anyway, I don't really have a lot of questions to ask you. You got a 40-year sentence on a plea bargain, correct?
Yes, sir.
Okay, and you served how many of those 40 years?
25 years and 9 months.
Okay, and you'll be getting out, a good time date is in 2033, regardless of our decision today, correct?
Yes, sir.
Okay, I don't have any other questions.
Just got one question. I saw you lost 45 days of good time, but I didn't see no DB reports. What you lost that for?
Well, I got transferred to Williamsburg, Franklin Parish, and it's a 6-man cell, and they came down to shakedown because they got a tip that a guy had a phone. So when they found the phone in the cell, there's nobody on up to the charge, but everybody got charged
in the cell.
But I got it restored, and when I went to court, I beat the charge, got dismissed, and I got the 45 days restored.
So it wasn't drugs; it was a cell phone.
Yes, sir. But on my route sheet, I have it. It showed that it was restored because it was.
Yeah, I see that.
Yes, sir.
Okay. All right. Is that all you got, sir?
That's it.
Anybody else got any questions?
I got one. I got something that I noticed on your commutation application, which goes back to, I didn't hear you say you took any crime victims awareness classes when you were talking. I might have missed it or something. Did you get anything that said crime victim awareness?
No, ma'am. The facilities that I was at, they didn't have that program, that class.
Okay, well, I did notice that after all these years, when you put in for your commutation, it asked what was the reason, in your own words, for the offense. And one of the things that you say is because I just couldn't bear having my only child taken away from me for no reason besides her daughter's mother being spiteful. So, I don't know.
I don't remember. I don't recall that right there.
You don't recall that? Well, that was part of your statement, so maybe you want to kind of rethink that. That was something that stood out to me. Okay, thank you very much.
Well,
All right, I don't see any other questions, Mr. Augustine, so I think we are prepared to vote. Mr. Prater voted first.
Okay, because of the victim opposition, which was very touching because of the other law enforcement opposition, because of the fact you took a plea bargain and because of the fact that you gonna get out earlier than expected anyway, and you took a plea bargain 40 years and you took someone's life, I don't think you've served sufficient time, although I wanna tell you, I'm impressed with your behavior and the efforts that you've made there, so I don't wanna leave you without hope or anything, but I do honestly feel like that you need to go ahead and serve some more time.
Mr. Freeman,
I concur with Mr. Prater.
Mr. Tillis,
I agree with Mr. Prater.
Mrs. Stapleton.
I concur, Mr. Prater.
All right, Mr. Augustine, received 4 votes to deny your application today. So today your application for commutation's been denied, sir. Good luck to you.
Well,
Denied. To the surprise of no one. Like I put in the chat, I mean, you know, he had no support. Plus, he took a deal. They tend to not offer an approval, I've noticed, if you're in there on a plea. So, at least not unless it's really close to the end, and he's got quite a bit of time yet. So, not surprising. Let's let's go back to Texas, Judge Stevens.
Defendant waive a formal reading of the indictment and the arraignment in each of these cases, 24 CR 1726, the second degree felony of burglary of a habitation, and 24 CR 1727, the third degree felony of evading arrest or detention with a motor vehicle.
yes, he does, John.
Judge, I'm sorry, I have not sworn the defendant in or fingerprinted him.
Okay.
I didn't realize I don't have plea papers either.
There's no plea paper.
There's no
He's
plea paper.
pleading open to the charge. He does need to be sworn in.
And just go right over there for just a moment. She'll swear you in. Thank you. So here we've got on the burglary, you've got the second degree felony and then a prior conviction. Are we just going second degree felony, gentlemen?
Going on both counts, both charges.
Okay, so that's going to be enhanced to a first degree felony. That's right.
It's just my understanding.
I mean, that's what the law would do. Okay.
I think he does need to sign some papers saying he waives a jury trial. I don't think he can just do it open like that. He's got to at least sign.
Yeah.
The admonishments and the waiver of jury trial after we're done.
And in this evaded arrest or detention, a third degree felony, we've got a prior conviction there. Is that going to be used as well? Does this third become a second degree felony punishment because of the prior?
Yes. Take the deal on surgery. Then you need to do the paperwork over the key for the,
Here, give me a copy of one of the
Y'all need to do the plea
papers, please.
He's gonna do plea papers.
Let me show you where you need to fill in. Okay.
But I've extended a cap offer to them, Judge. He's gonna include that. So we should have some plea papers. That changed.
And it'll be on the computer, but you got the punishment range, then.
FF8 is what he's telling you.
This needs to.
He says, it's only him if he's signing it then. See, I just do the counts.
I didn't do any of it. I didn't even the judicial confession. Okay. We need to see the paperwork. Well, he's doing it.
All right, I've got asterisks on the ones, when you get, when it's on the pad, you need to fill out those portions. And the ones that aren't filled out, like the last one, he's not waiving a right of appeal, apparently. Well, or he can, but since it's not agreement, he can, if he doesn't like it, he can waive it, but he's.
I think they're agreeing to take my agreement and cap it at 8 years, Judge, with change.
I understand.
It's right.
Okay, so there is an agreement then.
Yes, it's a capital pay.
Okay, then it's a, you know, you gotta do the regular plea agreement. Yes, sir. On each case is capital pay, is that what it is?
So we only need.
So
count
what
one on
you,
each.
you only need to do count one on each case. We don't need to worry about the enhancement count.
Yes, sir.
Yes, sir. All right.
Sorry.
That's okay. Wait, what else? Who do we have? We got some other folks here. I've got Evan Benjamin. And where's he?
They're all in the back, Judge.
In the back? Also, okay, thank you. Traylon Benjamin. Why it's not Benjamin Traylon, I'll never know, but it's Traylon Benjamin.
Harris.
While we're waiting on the next contestant, I just want to thank you all again for joining us here today at TCF. Hope you all have had fun. A few more minutes left, but wanted to say thank you. Also, if you have not done so yet, please do join us on Discord. There's a link down in the description of the video. Be able to get alerts every time we post and go live. Gonna start building out some community over there. Obviously, we just spun that up a couple weeks ago, so it's still a little sparse, but we're working on it. The post-game show, hopefully starting next week, will happen over there. And as well, that crawl that you see on your screen now with the news. In the next day or two, I still have to finish up a couple things, but we'll be posting that entire news feed over there. So if you see things that you want to research, you can do it from there. Anyways, back to Judge.
You were attorney and the state's attorney. Does the defendant waive a formal reading of the indictment and the arraignment here? Can we proceed in summary?
Yes, Judge.
In summary, sir, this indictment handed up on July 16th of this year alleges in summary that on or about February 15th of 2025 in Jefferson County, Texas, you committed the third-degree felony of intentionally or knowingly driving a motor vehicle that became involved in an accident resulting in bodily injury to another. And knowing that the accident had occurred, you intentionally or knowingly left the scene of the accident without giving your name, address, registration number of the vehicle.
Yes, sir.
And that you were driving or the name of the liability insurance carrier that you had, and without rendering reasonable assistance to the other party who was injured when it was apparent that they were in need of medical treatment. And this is, if convicted, a third-degree felony. Do you stand by? We got problems.
Transportation code's not gonna be in the penal
It's
code.
not gonna be in this one, is it?
No, sir. What are you looking for?
The statute. See,
I don't think this is that weird third degree.
no, it's, the caption says collision involving serious bodily injury. Serious bodily injury is not alleged in the body of that paragraph. It says bodily injury only. Yes, sir, but I think is, that's why I want to look at the statute to see if that makes a difference.
Is that? They're looking at saying word, the caption versus the body of the indictment. Don't know that the caption doesn't have this reason to be. But. I am living here, so.
I think it's a crime. It's a crime. I think it's all in the level, the punishment range. I think bodily injury and leaving, I thought that was a state jail felony. Because we tried that one. That was a big trial we had last year. That was for everybody we had dealt with some issues for the first time. But you see, it alleges in the caption serious bodily injury, and I think that has a different punishment range.
50021 is actually entitled collision involving personal injury or death.
C1B, subpart C, subpart 1, subpart B. What is that? That's what y'all alleged in the caption.
C is 1, B is, yes, they did allege serious bodily injury. Well, that's for serious bodily injury. It should be.
What's the difference between bodily injury and serious bodily injury?
The punishment range.
Which is?
Serious bodily injury is 2 to 20. Bodily injury is, yes, that's the strange one. It's a 3rd degree, but it's punished by imprisonment of the Texas Department of Criminal Justice for not more than 5 years. Or county jail not more than 1 year, and a fine not to exceed $5,000.
All right. That is bodily injury.
Yes, sir. And that's what's alleged in the indictment, I believe.
Okay, what subpart is the caption states C1B? Do we need to correct that?
3rd degree.
Yes, to.
It should be C2. Okay, so you have wrong on your things. Yeah, that's it. The technical name differs from the timing. Would be so it should be 550.021 C2.
And B is in boy?
No, just take the B out because 2 is, it just covers what the punishment range is after that. It takes it from a 3rd degree to the.
So this is a special 3rd degree felony?
Yes, Your Honor. It's 5. Punishable up to 5 years.
And again, the caption is, we're taking out serious. Is correct? Everybody on this? Hold on, sir.
Hold on.
Let us talk here.
It's not a day for day.
We got to figure this.
He's just asking a question.
I understand, but let's get it.
Right. Yes, sir. Yes, sir.
For the court reporter and for me. Collision involving bodily injury. Everybody agree with that? So I'm deleting serious.
Yeah.
And then third degree felony is a special 3rd degree felony. Correct?
Correct. Up to 5 or $5,000 fine. And it's normal calculations on eligibility.
All right. Is there a minimum?
No.
Okay.
It just says up to 5 years.
Is it not a school zone?
No. So what? That's no. This is just a weird transportation code. If you hurt somebody and accidentally leave, it's just a weird 3rd degree felony. It's just got strange.
Yeah, we tried this a year ago, so, and then it was a very confusing case to handle.
Just for TCF purposes.
No.
It's not. It's not ag. Yeah, it's going to run concurrent with your stuff. So it's not going to mess with it. This is not something we'll mess with you anyway.
All right, changing. I've got up to 5 years imprisonment, or what? What's
$5,000 fine or both?
No, There's no lower jail confinement.
There is
option?
there is an option of up to 1 year in the county jail, I believe was one of the options. Yeah, it's a strange deal. There's another option you can do up to 1 year in county jail. But it makes it a third degree felony the way it's alleged because it has prison time as part of the punishment or potential punishment.
But jail is an option.
Yes, sir.
Well,
I
Under the,
did-
under the same,
Under the same statute, but it's just a weird third degree felony.
Legislators screwed it up.
yeah, but because it loses the definition of a felony.
Well, it
If it's
does
up
if,
to 1 year in jail.
yes, sir. If you go a certain way, you can't.
Oh, yeah.
Yes.
Because
it's because
of the sentence length?
So that's why it's an odd statute, but we're proceeding under the 5 years penitentiary time is the deal. So that's all he needs to know really. And it's running concurrent with his other charges he has out of different
Okay,
places. So
and the fine
it's up to $5,000.
So
This is not changing anything to you, it's just the caption and the.
the offer is 5 years, 10, it's not offering you 1 year's county jail.
No. Okay. So, and it's run concurrent with whatever you got. It's non-aggravated, so you're getting credit for all the time you got.
You're in the same spot you would have been before all this stuff took place.
Yeah.
We're just,
All right.
we're correcting the.
The punishment range carries with it here, sir.
It's not.
And what the court has done for the record is the cap, let me speak so she can take it down here and y'all can talk here in a minute. It is indicted incorrectly, but we're fixing this. The caption states collision involving serious bodily injury. The court has corrected that to erase the word serious. So the offense is collision involving bodily injury. And it is pursuant to section 550.021 subpart C, subpart 2 of the transportation code. I am deleting subpart C, I'm deleting subparts 1 and subpart B of the caption. So that again, it will read section 550.021 subpart C, subpart 2. The court has also added, this is to the third degree felony. It is actually a special third degree felony, which carries with it up to 5 years imprisonment. And is it or?
Yes, sir. No, it's or meaning. And or, you mean the fine, and or fine, $5,000.
This one.
No. Is it or is
This
it,
doesn't change.
is it up to 5 years imprisonment
And a fine up to $5,000.
and a fine up to $5,000? Okay. Wow.
Mike, you want to do 3?
Huh?
You want to do 3 for
No.
now?
So do you understand your punishment range? Y'all have been talking, you're not listening to me, and I've got to get an answer, sir, for me. Do you understand what you're charged with? We have corrected it, and look at this mess on this indictment, but that's what we're having to do to make sure that it's corrected because you were facing a lot higher punishment than you should have been facing. So we've corrected all of that. You were looking at no more than 5 years imprisonment and a fine up to and no more, and a fine not to exceed $5,000 for this offense of collision involving bodily injury. Do you understand? Yes, sir.
It's not a caution.
Yes. Yeah.
All right, I've got to fix this here on this page.
Which county is that out of? Jasper.
What this is control itself. It's just shorthand. This is what controls. What says on the body of the indictment is what matters. What's up here is helpful shorthand notes. So that's all he was correcting. He was saying this was reflecting what's in here. So doesn't change anything. You're still good. It's not aggravated. It's not school zone. You're gonna get CC.
It's a very weird statute, which, like I said, we had a trial of this last year, and that's how because it's a rare event to try a case like this. Because generally the circumstances at the scene are dealt with by the DPS or the police, and it's deemed generally their work at the scene controls what the facts are going to be, since they're the ones who investigated. And then it becomes more of an issue of figuring out what the punishment range is so that the jury can understand. And it is because it's all under the transportation code, not under the penal code, where most of the criminal laws are found that we deal with in this courtroom. But in rare cases, you've got cases from the Drug Controlled Substances Act, you've got cases from the transportation code, but most of it is in the penal code. And that's when there's an exception to that, we've got to pull that book and look at it specifically, because the legislature wrote those laws differently than they wrote the penal code in general. And that's one of these unique situations that we're dealing with. The agreement that's been reached is whatever sentence shall not exceed 5 years imprisonment, which means we are looking at up to 5 years in prison.
Did you put a cap on it? No, I said 5 years.
That's 5 years capped on the statute.
Oh, I
Did
thought
you
you
just tell
well,
me?
you said what
5
was
years.
looking, okay, I thought you were
We're
talking about the
looking at
agreement.
up to 5 years imprisonment, and a fine up to $5,000 can be assessed. Also, you could be placed on deferred or unadjudicated probation, correct, everybody?
Yes, Your Honor.
And also, he could be placed on regular probation.
That's
which
correct.
means he could be sentenced up to 5 years in prison, and that could be suspended, and you could be placed on regular probation, which could be up to 10 years in length on the probation. So you've got the normal options that most people face, but you're looking at less of a maximum than most people face for a third degree type. Most of them are looking at up to 10 years. And you cannot be sentenced to a term of imprisonment longer than 5 years. This says this will run concurrently with other,
Other county cases.
That's what that word is?
It's abbreviated, Judge, outside of the county. The pen is.
Okay, what are we talking about for the record, so it's clear? Does he have cases in other counties?
That are taken.
Has convictions, and I believe you said Newton, Jasper.
Jasper and.
Middleton and CC.
All right.
About 8 years sentence.
If I follow this agreement, sir, you have no right of appeal of your case. Do you understand?
Yes, sir.
How do you plead to this special third degree felony of collision involving bodily injury? Guilty or not guilty?
Guilty.
Are you pleading guilty voluntarily and because you are guilty?
Yes, sir.
To show you what's marked as stand by. States Exhibit 1. Did you sign that document voluntarily, understand it, discuss it with your attorney? Are the contents all true and correct? Yes? You have to speak out so she can hear.
Yes, sir.
States Exhibit 1 is tendered into evidence.
Objection.
Without objection, yielded. Among other things, this states you are mentally competent to enter your guilty plea. It's freely or voluntarily made. You know what you've been charged with. Is this your man right there?
Yes, Your Honor.
Okay.
Yeah.
And you were giving up your rights to a jury trial and the rights to the appearance, confrontation, cross-examination of witnesses. You were totally satisfied with the representation provided by your lawyer. All of this is true. And you were pleading guilty voluntarily, knowingly, intelligently,
Yes, sir.
because you are guilty. All of this is true, so help you God.
Yes, sir.
States Exhibit 1 is made a part of the record for all purposes. Pre-sentence report will be prepared. We will return, right? We
This
gotta
is
have a
not,
pre-sentence.
this is 5 years on a capital, 5 years.
5 years. No, no need for.
Stand by.
That's why I was asking you a while ago when you were talking about up to 5 years. This is a 5 year.
Oh, I thought that's what y'all had said. It's a cap of 5 years.
No,
So
no,
this is just 5 years. Okay,
Sorry,
sorry.
5 years with his back.
All right. Do you understand? If I said up to 5 years, that's my fault. The sentence is, you would, the agreement is you would be sentenced to 5 years in prison, and this is going to run concurrently with other cases in other counties.
Yes, sir.
All right. That's what makes the deal. He's by law given, I don't have a say in it. By law, you get credit for all time you have served in connection with a case.
I'm just gonna hold on you.
And you're gonna know more than I do about how much time you serve. Again, sorry. Pre-sentence report is waived.
Yes, Judge.
All right. If nothing further, I'm going to find you are pleading guilty voluntarily, Mr. Benton. You are mentally competent to do so. You understand and appreciate the consequences of pleading guilty. There's sufficient evidence supporting your guilty plea from State's Exhibit 1 admitted here to find you guilty beyond a reasonable doubt. I now find you guilty beyond a reasonable doubt of this special third-degree felony of collision involving bodily injury under Section 550.021, Subpart C, Subpart 2 of the Texas Transportation Code. I am following this agreement. You are hereby sentenced to confinement in the institutional division of the Texas Department of Criminal Justice to serve a term of 5 years. This sentence shall run concurrently with other cases that you may have pending and disposed of in other counties, and you will be given credit for all time you have served in connection with this case. She knows, she can figure that out if you want to know right now. Do you understand what has happened today, sir?
Yes, sir.
Anything else? Okay, that is all. Thank you.
And that is all for us as well, my friends. Steven's had an interesting day today. He might need some quiet time with a good book or some music or whatever it is that soothes his soul, because he's been grumpy today. But hopefully he, finds something, and tomorrow's a better day for him. But I think today was a great day for us. Got to see some good court, got to hang out. Appreciate all of you. Thank you again to Lindsay and to Michael for gifted memberships. Very much appreciate that. Thank you to everybody else for participating in the chat today and for joining me here. Had so much fun. Let's do it again tomorrow. 10 a.m. Eastern, 7 a.m. Pacific, 45 minutes early for channel members. Please do all the stuff that we ask for, like liking, sharing. Sharing's a big thing right now, not just for us, but for any of your favorite creators on YouTube. Help us all out. Post us everywhere. Post us often. We need it right now because YouTube's being weird, so that is helpful. But if nothing else, just show up and chat and participate, and we appreciate that. So look forward to seeing you all tomorrow. Go have yourselves a great Monday. In the meantime, take care. God bless.